May pray for listing an RSA matter, the next Thursday.
When?
Next Thursday, today is Thursday, next Thursday.
For what purpose?
Because the 2017 matter, my lord, there is a person, the appellant is also my lord.
No, in which column? Hearing column or order column?
Hearing, my lord.
Sorry. Before vacation, we could not accommodate you. After vacation, after vacation, you can choose any day.
After vacation, any day.
After vacation, any day.
24.
Okay.
24 October.
Obliged.
Wait, please, your lord. These three MSc appeals, my lord, are last listed in the year 2021, my lord. May be listed for orders next week, my lord, any day.
Next week,
Date to be fixed by the
in
ministry.
which column?
Orders, my lord. Orders.
Order column?
Orders.
Okay. Next week.
Next week.
On 13.
May pleases you, Lordship. I beg to mention one transfer petition, Your Lordship. I had already been filed in 21/8/2024, but the matter has not been listed. And there
When
is-
do you want?
Yes, Your Lordship, tomorrow itself, Your Lordship.
Tomorrow, not
because-
possible.
Because on 9/9 matter.
Maybe
Has been.
next week.
On 9.
9th, Your Lordship, on family court, Your Lordship, the date has already been fixed.
Maybe you inform the family court that the matter is pending before the High Court.
for
Tomorrow,
submission.
not possible.
9 September.
Not
May
possible.
pleases.
Yes.
Please.
May it pleases your
Yes.
lordship. Lordship, I pray for listing of an unlisted matter for motion.
Or
For motion.
when?
CRPIO, if possible tomorrow, because the
No,
matter is
no, tomorrow
for-
not possible.
for execution also.
On Wednesday, 11.
Deeply obliged.
May I please your lordship? My lord, one matter, revision that will be listed on Monday, that was filed on 3rd of this month. The urgency is because on 9th, my lord, matter is fixed on it one.
When? When it is fixed?
It is on 9th.
So tomorrow not possible.
Tomorrow not, my lord, on 9th.
Okay.
Lots of this.
May I please, your lordship. Lordship, I beg to mention an IA for delay condonation in a MSc appeal, my lord. The matter has been pre-settled in the meeting on 14th, my lord. For the Lok Adalat, substitution needs to be allowed, my lord. IA for substitution and delay for August, my lord, on any day.
Oh,
Okay.
when do you want?
My lord, Monday,
On Wednesday.
Monday.
Take it on Monday.
my lord, and one vacating application, my lord, for orders, my lord.
When?
My
On
lord, any day.
13.
30.
Deeply obliged.
May I please, your lordship? Lordship, I'm praying for listing IA lordship. Its connection with RSA lordship. Lordship, some urgency is there, lordship. Title execution case was fixed.
When
is
do
fixed
you want?
Today, lordship. Today
Not
lordship.
possible.
Some urgency is there, lordship.
Maybe.
7 is fixed for.
No. Today, tomorrow not possible. Next week, any date you can choose from him.
On 11th, Wednesday. 11.
Can it be tomorrow? Lord? Otherwise, executed.
Sorry.
Land lordship.
You file application before the trial court.
Bless lordship.
May it please, your lordship.
Yes.
I beg to mention item number 20 with the consent of other side, my lord.
Item number?
20. It is this hearing matter, my lord. The matter may kindly be adjourned, my lord. I have taken consent from other side, my lord.
You were appearing for
Respondent number 9, my lord.
your good name?
M.S. Talukdar.
Mr. M.H. Talukdar, Learned Counsel for the respondent number 9 with consent from the other side. Press for listing the matter on
After a week, my lord.
after a week. Prayer allowed. Yes.
Please, your lordship, I am listing, prepare for listing of 2 matters. One is RSA and one is CRPIO.
When?
RSA may be fixed on 17,
17,
10/9,
10, 9.
10.
Okay.
and CRP may be kindly 13.
Okay.
I left. May I please, lordship, therefore listing a 14 matter, lordship, on next week, lordship.
Next week. Okay. Take a date from him.
And the pair, lordship, for listing a MSc appeal, lordship. It's
When?
next week, lordship. On 18.
For
order column.
okay.
18 September column.
May I please, your
Ah.
Honor, I beg to mention orders item number 9, lordship. Lordship, yes, lordship. Lordship, my senior assent is some difficulties
Mm.
for his mother's treatment, lordship. for kindly take up the matter on Thursday, Lordship.
You inform the other side?
Yes,
Yeah, Lordship.
Any objection?
No, Lordship.
No. Acha, okay.
Next
Miss,
step.
your good name?
Miss A Begum.
Miss A Begum, Learned Counsel appearing on behalf of Mr. S. N. Tamule, Learned Counsel for the applicant. With consent from the other side, press for listening the matter on
Thursday, Lordship. Yes,
Thursday.
yes, Lordship.
For order, your Lordship.
Okay. Bear a lot.
Oblige, Lordship.
Obliged.
May I please your lordship, I beg to mention for listing of one RSA matter for orders on 12th of September, your lordship.
Possible 12.
Thursday, there will be so many cases on 13th.
13th. Oblige your lordship.
Wait,
Yes.
Your Lordship. Lordship, I beg to mention an IA related to a RSA matter. There is urgency, my lord. Execution has already been issued on Monday, my lord.
Monday, possible, Kabir?
Mon-
Okay.
Obliged, my lord.
May I please your lordship, I beg to mention for listing of a RSA for orders, lordship.
When?
Next week, lordship.
Okay,
On
take a
18th.
date for me.
18th September.
May I please your lordship, I beg to mention one RFA. It was last listed on
When do you want?
Next week, lordship,
On 20 September.
20th. Much obliged.
May please the Lordship, with the consent of other side, I beg to mention item number 25, madam. Supplementary call this one. Can it be taken up next week? Any date convenient to this court?
On the prayer being made by Mr. M. S. Odhuri, Learned Counsel for the accused, rest list the matter on
Next week, any date?
On-
convenient?
13th.
13th.
I'm deeply.
Okay, okay.
May I please your lordship, my prayer is for listing one RFA for orders, lordship, next week.
On 18th.
And another is CRP IO lordship, which was last listed, 2 days listed but not reached lordship.
On
That is
23rd.
also next week, if possible, orders matter lordship.
Next week, no, not possible. Lot of matters have already been fixed.
18th, what the cases on 18th?
Lordship, I beg to mention one IA for listing in orders. May it be on next week, lordship.
On 18th?
Much
18th or 19th?
19th. Much obliged. May it please your lordship. Lordship, in regard to item number 3, I pray for an adjournment.
Item number?
3. Only for the day, lordship.
You are for
I am for the petitioners.
petitioner. Your good name? Miss Idas. You inform the other side? Miss Idas, Learned Counsel for the petitioner with consent from the other side, press for listening the matter. When?
Next week, any date except Monday.
On 20th. 20. 20th September.
Deeply obliged.
Items from daily list for motion, item number 1.
May I please, Lordship? Lordship, the fact of the case is this, Lordship, that the respondent is a plaintiff. Filed a title suit for declaration of right title interest recovery of possession, in which the present plaintiff was not one of the defendants. So after conclusion of the trial, the learned trial court has dismissed the suit of the
No,
respondent.
Mr. Roy, the stand taken by you is contradictory
How
as per the impugned order.
In what manner, Lord?
It is indicated in the order.
Improved order, Lordship.
22/7/2024.
Which para, Lordship?
Hmm?
Which para contradictory?
Last part?
First part.
Last part of paragraph number 6,
Page.
page number 3. It appears that
Page number, Lordship, sorry, my lord.
273.
Three.
273.
Three of the impugn order.
It is Lordship, I am of the view that the document sought to be introduced.
No,
by
no, no,
the-
no, this last part of paragraph number 6.
It appears that by introducing documents mentioned in the instant petition being number is 9, appellant is trying to submit that the respondent is already in possession of the said suit. This court is of the view that if appellant admits that the possession of the suit land is with respondent number 1, the instant appeal itself would not be maintained. That is not correct finding, Lord. Fact of the case is this, Lordship. The present petitioner was not a defendant in the suit. So decree cannot be executed against him, Lordship, that is against the present petitioner. He was a stranger to the suit, Lordship. Then when the execution was filed by the respondent, Lordship, the Nazir Haskar along with the police help and possession was delivered to the decree holder. But as I was in the possession and I was not one of the judgment debtors or defendants, Your Honor, the Nazir cannot execute the decree against me, Lordship. So the possession was delivered and that Your Lordship will come to know from the, I have filed that relevant document, Lordship. That is, Lordship, will you please to come page 111, Lordship.
Yes?
111, 111. Annexure 8, Lordship, page
Hmm.
111.
Hmm.
Here, Lordship, the first party is Sadhan Das, that is the respondent, plaintiff, decree holder. Second party is the present petitioner, Anil Chaudhary, Lordship. And Lordship may come to page, Lordship, 112, para 1, last para. That the first party shall construct a soap premises having floor area more or less itna square feet in the scheduled land, and the same shall be let out to the second party for monthly rent as a stated same shall be payable by the second party to the first party. Para 2, that the first party intend to construct a multi-storied commercial building upon the scheduled land following disposal of all the litigation dispute involving the scheduled land, and since the construction of the building are started, the second party will be liable to vacate from the said soap premises by a month notice. This shows, Lordship, that my small soap, Your Honor, which was not a position was not given by the Nazir. And the Nazir, Lordship, also in his report stated this fact that Your Lordship will find page 105, Lordship. I was not evicted while executing, but other actual defendants were evicted. Lordship, will you please to come to page 105.
Hmm.
105 and here 7, Lordship. This is Nazir report of title again.
Hmm.
On 6/6/11, as per the writ of delivery of possession issued by the Honorable Court with the help of police officer, Mandal Kanungo and Jarikarak, I had visited the scheduled mentioned land. Mandal has measured and demarcated the decretal land. Over the scheduled decretal land, the judgment debtors are having a stationary shop with the northern side and doing business, and on the back side residing over the said land. From the said land, as per the order of the decree, the house and shops of the judgment debtors have been demolished and removed all the articles and handed over khas vacant position of the suit land to the decree holder. Second para, it is mentioned herein that over the said disputed land, one person, namely Anil Chaudhary, I am the petitioner, has been doing his business in the name of Gift Plaza place and measurement 15x10 as per the amicable discussion between the decree holder and the Anil Chaudhary. The DH has asked me not to demolish his soap premises and compromise verbally about the position over the said soap premises and allowed Anil Chaudhary to run his business therefrom. And accordingly, the show premises of the gift palace of Anil Chaudhary left out undemolished, Lordship. This is the report of the Jari Karak, Lordship. So I was not evicted, Lordship. What happened, Lordship? Violating the terms and conditions of the agreement, the respondent decree holder plaintiff, Lordship, again filed a petition before the learned executing court that Anil Chaudhary, that is the present petitioner, he was not evicted. So second writ of delivery can be issued, Lordship. So thereafter, Lordship, I have filed an application under Order 21, Rules 97, 98, and 101 of the CPC, Lordship. The provisions of Order, Lordship, 21, Rules 97, 98, 101 of the CPC, Lordship, proceed just like a suit. Both parties must adduce the evidence against which title appeal is maintainable as per Order 21, Rule 103 of the CPC, Lordship. So that my petition, the learned executive court dismissed my petition without recording evidences of the both parties, Lordship. So thereafter, I file a title appeal, which is pending before the court of the learned additional decision number 3 at Kamrup, Guwahati, Lordship. In that, when pendency of that, during pendency of the title appeal, Lordship, I come to know that the present respondent defendant has filed a suit, Lordship, for confirmation of possession of the same suit land, Lordship. And this document I come to know only in 2024, Lordship. Then I filed a petition before the learned executing court that just now I have come to know that the respondent plaintiff has filed an application, have filed the suit, wherein they, the respondent defendant claimed for confirmation of possession over the suit land. Now, Lordship, the question is this: when the earlier on 6/6/11, the Nazis had delivered the position of the decretal land except the a small scope of the present petitioner, Lordship. A decree cannot be executed twice under Order 21, Rule 35 of the CPC, Lordship. And in this respect, the law is well settled, Lordship, 1961.
No, can it be said that without delivering of the position, the decree stood satisfied?
Yes, because it is the respondent decree holder, plaintiff, Lordship, who has entered into an agreement, allowing me to continue with the gift plaza soap measuring tape 15 feet.
Yes, yes, Mr. Moya.
10.
Lordship, so far my submission of my learned senior brother is concerned, it is subject matter of the appeal. Now the present revision, Your Lordship. In the present revision, they filed an application. There is application, Your Lordship, at page Annexure 29, page 243.
Annexure?
Annexure 29, page 243. During pendency of that appeal,
Page number?
page 243, Lordship. Annexure 29.
Yes.
Lordship, got it. An application under section 151 of the CPC that is filed by the present petitioner. The humble petition of the appellant, he was the appellant, he is the appellant.
243.
243. That the instant appeal has been filed by the appellant under Order 21, Rule 103 of the CPC and read with Order 41, Rule 1 of the CPC and also read with Section 151 of the CPC against the judgment and decree dated 23/12/2010 passed in Mizze case number so-and-so arising out of title execution case number so-and-so at Guwahati, and the same has been fixed today for hearing before this honorable court. That it is pertinent to mention herein that while preparing for the hearing, this appeal by the learned counsel in consultation of with the judicial records, response number 1, it has come to the knowledge of the information of the appellant that already the response number 1 as plaintiff had filed title suit number 438/17, which was decreed ex parte by so-and-so, decreed so-and-so, in respect of the same plot of land as involved in the present appeal, wherein the response number 1 had obtained the decree for confirmation of possession over the same suit land, whereas the case of the so-and-so, so-and-so. That the appellant states that immediately after having knowledge information about this title suit, the appellant had filed for the certified copy of the plain judgment and decree dated so-and-so, which could be obtained today As such, the appellant prays before your honor to accept the same for fair and proper adjudication of the subject matter in dispute. So basic contention in the application is that the appeal is pending, your lordship, on the basis of a judgment passed by the learned trial court, executing court under order 21, rule 99, 101. Because that application was that he is not a party to this suit, he has an independent right. So that is why that decree cannot be executed. That is separate part, and that part has been disbelieved by the honorable trial court, and accordingly judgment was passed against him. Against that appeal has been preferred in the year 2011. That was the year 2011, and part of that decree has been executed except this room. That means meaning thereby he is still in possession of the state, possession of the room. I am not denying that he is in possession of the land and he is to be evicted by executing the decree. So that is why he filed the application order 21, rule 99, and that has been pending, that is disposed of, and against that appeal was filed, preferred by him. Now his contention is this, that he is, though I am claiming that he is in possession, in fact, I have filed this suit for confirmation of possession. If as the property is in my possession, how can I file this suit? How can I execute the decree? That is different aspect. Now he is saying that the respondent, the decree holder is in possession of the land, so decree is not executable. That is not the contents of the appeal. His appeal is that he has an independent right over the decretal property, so he is to be made parties and decree is not executable without hearing him. That fact to be considered. Now, his claim is that as you have filed this suit for confirmation of possession, how can you execute the decree? That is different aspect. That question will be decided by the appellate court, not to be decided by the honorable court as a revisional court. His contention is that that judgment passed in the subsequent suit, that is to be looked into, that is to be taken judicial notice by the appellate court. Appellate court says that is why the honorable court rightly mentioned in paragraph number 6. Admittedly, a decree, I am coming to the impugn order, page 273, paragraph number 6. Admittedly, a decree is passed in favor of the respondent number 1, and pursuant to said decree, execution proceeding were initiated so that possession of the decretal land can be handed over to the respondent number 1. Now, appellant is resisting said execution proceeding on the ground that he is in possession of a part of the suit land, whereas the documents which the appellant is trying to introduce through instant petition shows that the respondent number 1 is in possession of the suit premises. It is not understandable as to how the said documents could advance or support the case of the appellants. It appears that by introducing the documents mentioned in the instant petition bearing number so-and-so, appellant is trying to submit the respondent number 1 is already in possession of the suit land. This court is of the view that if the appellant admits that the possession of the suit land is in respondent number 1, the instant appeal would be not maintainable. Correct. Now he is saying that I am not in possession, you are in possession. Then assuming that the trial court by appellate court take the judicial notice of that what conclusion will come out? That I am in possession, he is not in possession. But he is admitting time and again, that I am in possession of that decretal property. Decree is not to be executed against me because I have an independent right, and I am not made parties. So if he is in possession, and then I filed this suit because out of the entire suit property, only one room in occupation and possession. The rest portion are in my possession. That in the circle of that portion, I want to execute the decree. All right, title appellate court will decide. Appellate court will decide whether second time decree will be executed or not. That question as raised by today, that will be decided by the appellate court. Whether now the honorable court being a revisional court is to entertain this impugn order. Any wrong has been committed. You are saying that I am in possession, but at the same time you are saying that no, You are claiming that suit for confirmation of possession, you filed this suit. So you are in possession, you cannot execute the decree. That is to be decided by the appellate court, not by the taking the judicial notice of the judgment passed in suit. All right, assuming that yes, decree has been passed confirming my possession in respect of the entire decree land. Meaning thereby, does it mean that you are not in possession? You are in possession.
Okay, now tell me if he is allowed to introduce those documents.
Taking into consideration judicial
yes,
notice.
Yes.
Oh.
What would be the consequence?
Lordship, it will nothing but it will delay. It will delay. What will be the result of that consideration? He is claiming that I am in possession of the property, I should not be evicted. It is his claim. It is not a trial court. It is an appellate court. Appeal arising out of a title execution case. Now, whether the appellate court, honorable appellate court, take any document into consideration without section 41 rule 27, being an appellate court, under provision has been there. Being an appellate court, the appellate court is entitled to consider the document under order 41 rule 27 if it is filed. Because at that time, that document is not there. Only one provision has been made under order 41 rule 27, not other than that. They filed this application 151. All right. How that the honorable appellate court can consider it 151? It is an appellate court challenging a decree. Order passed under order 21 rule 99/101 is a decree. It's a title appeal. Is there any provision, your lordship, in the CPC that one before the appellate court, I being an appellant, I filed an application on 151 and that can be considered? That is why order 41 rule 27, its provision is there. Additional evidence that is to be considered. That was not filed. And that very purpose of this filing the application, not to otherwise. That is why the trial court, the appellate court, assuming it appears 7. I am of the view that the documents sought to be introduced hide instant petition are not necessary for deciding the instant appeal. It appears that the instant petition is filed just to delay the hearing of the appeal. It is an appeal of the year 2011. It was renumbered appeal. A decree was executed in the year 2011. Immediately after dismissal of their petition in the year 2011, they preferred an appeal. Since 2011, appeal is pending. And it has been renumbered as 2016 as 19A. Originally, it was numbered as 19/2011. And it was renumbered as 19A 2016. Since 2011 till 2024, that appeal under order 21 rule 99 is pending. That is why the appellate court is conversant with the records. That is why appellate court held, observed that it appears that the instant petition is filed just to delay the hearing of the appeal. It is relevant to mention here that the instant appeal is of the year 2016. Lordship, what happened? During pendency of the appeal, we preferred an revision application before this honorable court because matter is delayed. There is a direction from the honorable court to dispose of the appeal within 3 months. Even then, Lordship, 2 years has been elapsed. After 2 years, they filed this application. That is the very purpose. That is why honorable learned appellate court observed this. Now, what purpose will be served? I do not know. He is claiming that he is in possession. Now he tried to establish you are not in possession. I am not. You are in possession. That means, where are you? Why you filed this appeal? You filed this appeal to restrain the respondent decree holder from executing the decree to dispossess you. If I am in possession, you are saying that I am in possession, that means you are not in possession. Then the appeal will be infractious.
Okay. Yes, Mr. Roy.
Lordship, the learned appellate court completely misconstrued while coming to a finding at page 213 of the impugned judgment, Lordship. Because, Lordship, it is correct that the almost all the original defendants, Your Honor, who were the judgment there, they were evicted through the Nazir on 6/11 on 6 report, Nazir report I have submitted before your lordship long back. And my premises, which is a small shop measuring 15 feet into 20 feet only, Assam type house, your lordship. where I am earning by bread and butter, Lordship. So that as I was not one of the judgment debtor or decree holder, Lordship, decree cannot be executed against me. That's why, Lordship, the respondent plaintiff was compelled to enter into an agreement with me, and he assured that when the RCC building will be completed, he will be given the position of a room, RCC room. Till then, he will continue in the Assam type room, Lordship. So that was completely misconstrued. Rightly, your Lordship has questioned my learned friend. What prejudice will be caused to my learned friend if those two documents are taken on record? And the submission of my learned friend that the petition was under section 151 of the CPC, your Lordship is aware that the parties or a council may quote a wrong section or order, Lordship. That does not mean, but always that petition will be treated a petition under order 41, rule 27 of the CPC, which provides for giving additional evidence. I am not praying for giving any additional evidence. My only humble prayer is that those sale deed and the judgment and decree passed in this suit for confirmation of possession in favor of the respondent, that may be taken on record, Lordship. That is my only, that would not prejudice the respondent, Lordship, in any manner. Apart from that, my learned friend repeatedly that there was
the question is whether the learned appellate court can take note of the same at the time of hearing.
Yes, judicial notice can be taken by any court, Lordship. Judicial, that is the provision contained in the Evidence Act. Apart from that, Lordship, what is the law? Lordship, even at the one case of such fact came before the Honorable Supreme Court, where at the time of argument, a party wanted to introduce some document. The learned trial court rejected it. The Honorable High Court also rejected it. Then matter went to the Supreme Court, Lordship. And that, thank you. 90. Print लो ना. What? This is
Which paragraph you have relied upon?
Para, your Lordship may come to page, Lordship, page 661.
No, the earlier one. 1961 judgment.
Citation is Lordship 1994, Code SCC, page 659.
No, the earlier judgment. AIR 1961.
Oh, 61 is there. 61. Here, Lordship, in 1994, Supreme Court held at the stage of, for the instance of justice, proper adjudication, at the stage of argument also, the documents can be allowed. Either it is filed by plaintiff or defendant, 61. In 61, Lordship, the apex court held, 61 this one. In 61, Lordship, your Lordship, we come to, please to come to para 25, whether degree can be executed twice. Answer is no. Para 25. Para 25, Lordship. Lordship got it? It is true that the Nazi return showed that the defendant number 4 has not been bodily removed, but the same return also shows that it has not been so removed because of the certain arrangement arrived at between it and the decree holder, and as the decree holders had not required the removal of the defendant number 4 from the premises. Now under order 21 rule 35, a person in possession and bound by the decree has to be removed only if necessary. That is to say, if necessary to give the decree holder the possession he is entitled to and ask for it. It would not be necessary to remove the person in possession if the decree holder does not want such removal. It is done so to the it is done to the decree holder or to accept delivery of the possession under this rule without actual removal of the person in possession. If he does that, then the cannot later say that he is not been given that possession to which he was entitled under the law. This what happened in this case. The decree holders in the present case of their unaccepted delivery of possession with defendant number 4 remaining on the premises with their permission. They granted a receipt acknowledging full delivery of the possession. They permitted the execution case to be dismissed on September 8, 1949, and on the basis that full possession has been delivered to them by defendant number 4. The fact that they are put their guards on the premises is mentioned in the Nazi report would also show that they had obtained full possession. It was open to the decree holder to accept such possession. Having once done so, they are bound to the position that the decree has been fully executed, from which it follows that it cannot be executed anymore. In the case of so and so, exactly similar thing had happened, and it was held that the decree was not capable of further execution. It was there said as this.
That will be considered by the appellate court.
Yes.
Now,
My only submission in the slum. My learned friend is submitting the delay. I am
No,
ready
okay,
to do.
okay.
Let the appellate.
Yes, Mr. Bhuya.
Lordship.
If he want to submit those documents only for the purpose of taking judicial notice,
Lordship.
if he will not adduce any evidence in respect of those documents, how delay will be caused to you? Delay will be caused.
Delay definitely, your lordship.
My lord, I am ready
Because
to do
since-
argument on the title appeal day after tomorrow.
Lordship.
If that document is taken on
Lordship,
record.
one thing. Since
There is no
2011,
delay. I am giving
the
that.
matter has been
undertaking.
dragging.
No, if we fix a date, then
I am ready.
then
Lordship, that the condition precedent, that the while, if assuming that the document has been allowed to be take judicial notice, that what purpose will be served?
no, that is a different aspect. That is a different aspect that will be considered by the appellate court.
Lordship.
My
Then
legal.
no further evidence and will come because the appellate court there is no evidence.
That, Lordship, I may file a petition under
Lordship,
order 41 rule.
Lordship,
27.
that is why Lordship.
But
Now
no,
they
I may
want
not
to
file-
entry first.
I have instituted that.
There is a entry first.
Lordship, only I am.
They
ready to
want
do
the entry,
appeal title
after they will
appeal
come
hearing
another application on the portal on Rule
within-
27,
within a day
that on
or
the
two,
basis of
Lord.
that additional evidence to be required. That is the apprehension. That is my apprehension. They want entry first. Now they are saying that the entry has been given. After getting the entry, they will file an application under 41 Rule 27 to lead the evidence before the appellate court, and the matter will be again come back. This is the
No,
position.
Lordship, I will
That
not
is
fi-
the apprehension. I am
I am
saying.
giving undertaking, Lordship, I will not file any application under order 41 Rule 27 because I am having a merit in
That
my
is
appeal,
the-
Lordship. A stranger
Yes.
cannot be evicted, Lordship, when he is not a defendant in the suit, Lordship.
Undertaking is defending Lordship.
Now, I will not.
Now
Your
they
Lordship,
want
please
entry.
record.
And
Apprehension
on the
of-
basis of
My
that,
learned
after
friend is
getting
not
entry,
based on
they
sound
file an
footage.
application under order 41 to additional evidence.
Okay.
Lordship.
Lordship, may
Mr.
please to
Peter,
bear
learned
94
counsel for the
Supreme Court
petitioner
decision.
and
It is
Mr.
very clear.
R.K. Bhuya, learned counsel for the respondent. Order reserved.
Lordship.
This caveat will be heard.
24 of supplementary.
Caveat.
24 of supplementary list.
Wait, this is the lordship. My lord, the present petitioner before your lordship is a party to a proceeding which is pending before family court at Kachar, my lord. And in this case, my lord, what happened? On 16/7, my lord, she was given a last chance to cross-examine the plaintiff witnesses, fixing the same on 1/8/2024. We have annexed that order, my lord, which is at page 23. Page 23, my lord.
On 16/7/2024, last chance was given to you.
Yes, my lord.
So you failed to
No, my lord.
produce the witnesses.
No, man, I'm the respondent there in the proceeding, my lord. Wife, joined as wife as respondent, my lord, before the family court.
To
And I was
cross-examine the witnesses of the opposite party.
Yes, my lord, plenty witnesses. So I was present, my lord, along with my learned counsel, my lord. On that day, my lord, the plaintiff side took an adjournment. plaintiff side, my lord, took an adjournment. Husband side took an adjournment, my lord, and filing a petition. May I read, my lord? Petitioner is absent with step by petition number 2389 of the 15, stating the ground of his absence and absence of his witness. Respondent is present, that is the present petitioner, my lord. On perusal of the case record, it is seen that by order dated 16/7/24, the respondent was allowed to cross-examine the PW1, fixing 1/8/24 as a single chance, and the petitioner PW1 was directed to appear before the court with PW2 and PW3 today without fail. But today the petitioner PW1 and his two other witnesses remain absent. Moreover, the case is an old pending one of the year 2018, and so also for the interest of justice, the petitioner is given a further chance to face cross-examination of the respondent side along with his other two witnesses, else the case will proceed as per law. So I was present, my lord, and ready with my counsel was also there for cross-examination. Since they took an adjournment, my lord, the matter was fixed on 5/8. And then, my lord, I'll take your lordship to 5/8, my lord. I filed my Hajira, my lord, typed copy is there in page 24. But suddenly, my lord, thereafter, my lord, I have to file one application of adjournment, my lord, because my engaged counsel, amicus, my lord, fell ill, my lord. The page 26 is the typed copy, my lord.
So on that day, your engaged counsel could not appear.
My lord, she was there. She was there, but because of sudden illness, my lord, that application was filed with, and we paid a short date, my lord. But learned court declined to accept our prayer, my lord. So my humble prayer, my lord, the matter is today fixed before the family court for defense witness, my lord. So if an opportunity, lordship, as last opportunity may be given to us for cross-examining the plaintiff side witness, my lord.
Part Mr. Sotore, learned counsel for the petition. This petition under Article 227 of the Constitution of India is prepared by the petitioner, challenging the correctness or otherwise of the order dated 5/8/2024 passed by the learned principal judge family court Kasar, Silsor in FC, between bracket civil case number 244 of 2018. It is to be noted here that by the impugned order dated so the learned family court closed the cross-examination of the prosecution witness, plaintiff's witnesses by the respondent. Mr. Sotore, learned counsel for the petitioner, submits that the petitioner is a respondent in the FC within bracket civil case number 244 of 2018, which was instituted by her husband. The said case was fixed on 5/8/2024, and on that day, the amicus curiae appointed to defend the case of the petitioner filed Hajira, but she could not able to cross-examine the witnesses of the respondent herein on account of her illness. But the learned family court, by the order dated 5/8/2024, by the impugned order dated so and so, has closed the evidence. Close the evidence. Mr. Sotore, learned counsel for the petitioner, submits that one last opportunity may be given to the petitioner to cross-examine the witnesses of the respondent. Further, having considered having heard the submission of Mr. Sotore, learned counsel for the petitioner, I have carefully gone to the petition and the documents placed on record, and also perused the order dated 5/8/2024. It appears that on that day, the learned amicus curiae appointed to defend the case of the petitioner remained present in the court, but she could not cross-examine the witnesses of the respondent on account of her illness, but the learned family court has closed the prosecution evidence as no document was submitted to substantiate the plea. It is to be noted here that right to fair trial is a fundamental right which includes giving a proper opportunity to both the parties to defend their cases. In the case in hand, by closing the evidence of the respondent side, the present petitioner deprived of the opportunity to cross-examine the said witnesses. And as such, a prejudice will be caused to her in presenting her case before the learned family court. Where having considered above and also considering the submission of Mr. Sodhuri, learned counsel for the petitioner, this court is inclined to allow the petition. It is when the next date is fixed.
My lord, today is fixed for defense witness, my lord.
It is provided that the learned counsel for learned family court shall afford another opportunity to the petitioner to cross-examine the witnesses of the respondent. In the event of failing to cross-examine the witnesses on that day, the learned principal judge family court Kasar Silsor shall proceed to hear and dispose of the matter in accordance with law. In terms of this CRP, stands disposal.
So, the family court will fix the matter, my lord, for cross-examination.
Pardon?
Family court will fix the date for cross-examination.
Date is fixed today
Today, my lord. We'll intimate the family court,
on the next date to be fixed by the family court.
my lord. Deeply.
Item number 2 for admission. Okay. It's a landlord tenant matter, my lord. Actually, it should be hard, my lord.
My lord, it can
so
be
any-
disposed of at the admission stage, my lord. There are concurrent
Any other
findings
day,
on
maybe it's
point of default.
answer has come, my lord.
Because my lord, if the matter is admitted, my lord, it will take years to come.
So this is CRP.
CRP.
My lord, yeah.
Suit is of the year
My lord, this
2000.
is a landlord tenant matter, my lord. Evidence, many things are to be shown, my lord. Any other day, my lord.
So what is the difficulty on your part?
My lord, it may be taken up on another date, but my lord may fix a date. The suit is of the year 2001, my lord, long pending matter. There is bona fide requirement also.
So when to be listed then?
What not fix it in October, my lord. 29th of October. It can be
When?
finally had.
When?
29th of October.
When?
29th of October. 29th of October. Tuesday.
29th. So as agreed by learned advocates of both the parties, RSS shall list the matter on 29th of September for hearing,
For, my lord, for admission hearing.
for admission.
29th of October, rather.
Item number 4, matter for hearing under order 41, rule to CPC.
My lord. My lord. The Honorable Munsi, my lord. Honorable Munsi dismiss the suit. I am for the defendant. Dismiss the suit holding that landlord-tenant relationship was not proved. Then the first appellate court hold that that defendant is defaulter. The substantial question we have proposed in page number 19. The landlord-tenant relationship was denied and that was not proved. But unfortunately, no issue was framed. The suit was for declaration only. Suit was valued not on the basis of the rental value, my lord. Suit was, lordship will kindly have a look at page 19. No, sorry, page 21 first. That is the plaint. From the cost title, lordship will find this is not a suit for landlord tenant. Lordship will find at page 22.
Page number?
Page 21 is the plaint. The next page, lordship kindly have a look.
Yes.
It is a suit for declaration and permanent injunction, not for recovery of possession. And for jurisdiction, the suit is valued for rupees 1,10,000. But in the plaints, they have said that the rent is rupees 100 per month. That is 1,200 per annum, my lord. So that suit was not valued on the basis of the rental value. Suit was valued on the basis of the market value of the structures. And in 2015, the subject matter of the suit, that is the premises, that was gutted. I have constructed the house. So therefore, before the filing of the suit, the subject matter of the tenancy was extinguished. All those are not considered by the first appellate court. And the Munsif, learned Munsif, the trial court, original court, hold specifically the landlord-tenant relationship was not proved.
Where it has been held?
Lordship will find the lower court judgment 63.
Which part?
Lordship will find the issues are on at page 69. And lordship will find issue number 4, whether the defendant is a defaulter tenant in respect of the suit line. Page 73. Lordship kindly have a look at page 75, the discussion. 75. Hence the Lordship has got it. Page 75. Hence the credibility of the witness PW1, that is the plaintiff, has been completely shaken during cross-examination, and plaintiff has not been able to prove that the defendant number 1 was tenant during the lifetime of his father at the rate of 100 per month. Moreover, the rent receipt exhibited by the PW1 also shows that various rate of rent has been shown in the rent receipt at different times. However, it is also pertinent to mention that regarding the point that the defendant number was the tenant of the plaintiff, the evidence of DW1 could not be shaken during her cross-examination. As the plaintiff has failed to prove the landlord-tenant relationship between him and the defendant number 1, it is held defendant number is neither a tenant nor a defaulter tenant under the plaintiff. It was claimed by the plaintiff that I am the tenant under his father and thereafter under him. But no rent receipt has been produced to show that I have ever paid any rent to him.
Then where is the finding of the first appellate court?
Yes, my lord. The first appellate court judgment, lordship will find, it starts from page 85. And discuss that if whether that issue is that whether the defendant is defaulter is page 101. The all evidence has been discussed, my lord, and lordship kindly have a comes to Paragraph number 43. PW1 has very clearly mentioned each and every rent receipt in its evidence on affidavit, and also stated to whom the receipt were issued and by whom the receipt were signed and accepted. Not me, oh, my lord, it's somebody else. No receipt signed by me. It is not said by the learned appellate court also. The learned counsel for the appellant has advanced such and such issue ought to have taken into consideration the rent receipt exhibited exhibit 2033, which was issued on 81 and not on 92, and was received by Jatindra Chakraborty. I am not Jatindra Chakraborty, but very whimsically and wrongly only on the basis of the statement received in cross-examination of PW1, the learned trial court failed to appreciate the evidence of the plaintiff on record and came to the conclusion that it is not possible Jatindra Chakraborty to sign exhibit 33 on such and such. The defendant, though they has claimed that they have occupied the scheduled land since 1952, has failed to show any document that they have their names in records of right or that they have been paying the land revenue. I am not the owner of the land, my lord. So how could I pay the land revenue, etc.? The plaintiff, on the other hand, has proved exhibit 1, where his name along with the names of the property have been entered in the records of right of the said document remain unrebuted. The Jabamandi was produced wherein it was inherited by the plaintiffs and other legal heirs from their father. It is there. But there was no declaration sought for, my lord, that for the declaration of right title and interest. Had it been a case of right title and declaration, Your Honor, then the eviction can be sought for unauthorized occupation. But that declaration was not sought for. And consequently, relief was sought for, which is not permitted under section 34 of the Specific Legal Act. His only declaration is that the declaration that the construction is illegal. So therefore, the construction has to be removed. That is an.
So now come to your substantial question of law.
Page
Who is according
19,
to you?
Page 90.
Who is according to your substantial question?
I am
of law?
suggested so much, but I have so far what I feel, Your Lordship, the suggestion made by us is serial number 1, 3, and 5. 5 is also can be cut short. 1, 3, and 5. 5 can be cut short. It is, you know, we have stated much more than the requirement. I can cut short that substitution question number 5.
Okay. Part Mr. B. Dotto, learned senior counsel assisted by Mr. So-and-so, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure is directed against the judgment dated 30/10/2019 and decree dated 14/11/2019. Passed by the learned Munsif number 1, Tinsukia, in title suit number 17 of 2015. It is to be noted here that by impugn order, no impugn judgment and decree dated so and so, the learned Munsif.
And Munsif judgment we have not impugned, madam. That in our favor. We impugn
So
the
this
appellate
is
court
not
judgment.
impugn.
Munsif dismissed their suit, madam.
Impugn is impugn order
Impugn
is
the appellate court judgment.
Acha,
Yes.
directed against the judgment,
24th of
impugn
August.
judgment The judgment dated 24/8/2022, passed by the learned civil judge Tinsukia in title appeal number 5 of 2019.
Correct.
It is to be noted here that by the impugn judgment and judgment dated 24/8/2022, the learned civil judge Tinsukia in title appeal number 05 of 2019 and the decree dated 14/11/2019 has
Has reversed the judgment of learned Munsif.
has reversed and has set aside
Yes.
the judgment of the learned Munsif passed in title suit number 17 of 2015. Judgment dated 30/10/2019 and decree dated 14/11/2019, passed by the learned Munsif number 1 Tinsukia in title suit number 17 of 2015.
Correct.
Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and decree dated 24/8/2022, passed by the learned civil judge Tinsukia in title appeal number 5 of 2019 and the decree dated 14/11/2019. No, and the judgment dated 30/10/2019 and the decree dated 14/11/2019, passed in title suit number 17 of 2015 by the learned Munsif number 1 Tinsukia. This second appeal is admitted on the following substantial question of law. Number 1, whether without framing any issue as to whether there is any relation of landlord and tenant between the plaintiff and the defendant, and without there being any evidence, either oral or documentary, the finding of the first appellate court that the Schedule C Pakka house constructed by the defendant is illegal and liable to be dismantled, and that defendant is a heavy defaulter, is perverse. Number 2, whether the judgment and order passed by the learned first appellate court is perverse in granting the consequential relief in favor of the plaintiff when the plaintiff has not prayed for declaration of his right, title, and interest in respect of the suit premises, despite the suit being a declaratory in nature and form. Number 3, whether finding of the learned first appellate court is perverse in holding that the defendant has no legal right to construct any house over the Schedule A land comprising of the Schedule B premises, which become non-existent on 9/2/2015 after the same was damaged in fire, and that the defendant is a heavy defaulter. Without there being any specific pleading, as regard commencement of the tenancy and stroke or without there being any proof thereof when the defendant categorically denies the tenancy. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Recessal call for the record from the learned trial court as well as first appellate court. Please the matter after 4 weeks.
I is there, my lord.
I would like to read the class and state the disposal of the appeal.
Grateful, man.
Sergeant number 5, letters for orders.
Wait, please, your lordship.
Your lordship may come to the office note dated 2/9/2024. In regard to respondents 2A, 2B, 3, 7A, 7C, 8, 11, 8, 11, 13, 14, 15, 16, all these have been, notices have been served in regard to them. And in regard to 1, 4, 5, 6, and 12, unserved notice has returned back.
Heard Mr. S. Dr. Learned Counsel for the appellant. Office note dated 2/9/2024 indicates that notice issued to the respondent number 2A, 2B, 3, 7A, 7C, 8, 11, 13, 14, 15, 16A, 16B, 16C, and 17 returned with a report. No, returned with service report. Returned with signatures of the respondent and some other persons. Said office note also indicates that notice issued to the respondent number 1, 4, 5, 6, and 12 returned unserved with a report that the address is left and neither ID card nor unserved notice returned in respect of respondent number 2C, 7B, 9, and 10. Accordingly, it is provided that Mr. Dr. Sel take fresh step upon respondent number 1, 4, 5, 6, and 12 and 2C, 7B, 9, and 10. You take step on all the respondents. Then what to do in respect of respondent number 11, where illegible signature?
There also, I think, better to take fresh steps.
Fresh.
Yes.
It is further provided that the learned counsel for the appellant shall take fresh step upon respondent number 11, as the same was received by a person whose signature is not legible. Place the matter after 4 weeks.
4 weeks.
Number 6.
Here also, your lordship, may produce the office note dated 2/9/24, wherein AD card has been received back on respondent 1. And unserved notice has been received back in regard to respondent number 2A to 2C and 3. And in regard to pro forma, sir, the steps has not been taken.
What to do? You want to take fresh step or?
2 to 3 will take fresh steps. Regarding the pro forma, your lordship may give us some time so that we can
Pro forma.
take instruction
Pro forma.
regarding the pro forma.
Okay, heard Mr. S. Dr. Learned Counsel for the applicant. Office note dated 2/9/2024 indicates that notice issued to the respondent number 1 returned with
Illegible.
AD card of the notice. AD card in respect of the notice issued to the respondent number 1 returned with an illegible signature. So you take fresh step upon him.
1 to 4.
and neither ID card nor unserved notice returned in respect of respondent number 2A, 2C, and 3. And the said office note also indicates that steps for performer respondent has not yet been received. The learned counsel for the applicant submits that he has been awaiting for instruction in this regard. And it is provided that in respect of respondent number 1, 2A, 2C, and 3, the learned and R1 and R1, the learned counsel for the applicant shall take fresh step within a fresh step by registered post and also by usual process within a week from today. List after 4 weeks.
Obliged.
And number 7.
My lord.
Hmm.
This is for transfer of divorce proceeding, my lordship. My husband has filed the divorce proceeding before the district judge, Karimganj, my lordship. My parents' house is in Hailakandi. So distance between his house and Hailakandi is 29 kilometers, whereas distance between his house and the court of Karimganj district is more than 29 kilometers.
Yes, Mr. Dotto.
Your lordship, I'm ready to bear the expenses. On that count, your lordship may not allow the transfer. There is a judgment passed by this, passed by the Supreme Court. Like to rely on that.
Yes.
Is the copy. I would like to rely upon para 4 and 6. May I read your lordship? This court, para 4, this court is now required to consider each petition on its merit. In this case, the ground taken by the wife is that she has a small child and there is nobody to keep her child. The child in this case is 6 years old and their grandparents are available to look after the child. The respondent is willing to pay all expenses for travel and stay of the petitioner and her companion for every visit when the petitioner is required to attend the court at Delhi. Thus, the ground that the petitioner has no source of income is adequately met, except for stating that her health and is not good. No particulars are given. On the ground that she is not able to come to Delhi to attend the court on a particular date, she can always apply for exemption and her application will undoubtedly be considered on merit. Hence, no ground for transfer has been made out. Accordingly, we dismiss the transfer petition. We have, however, direct the respondent shall pay all the travel and stay expenses of the petitioner and her companion. So in this case also, I'm ready to pay for the travel expenses as well as the stay and boarding if it is necessary.
My lord, already 2 cases pending before Hailakandi, in Hailakandi, my lordship. That is DV case number 87 of 2022 and MR case number 83 of 2022.
Where you have mentioned it?
It is, my lord, paragraph 3 and paragraph 4 of the petition, my lord.
So, Mr. Dotto, in connection with these cases, you have to visit this place, this Hailakandi.
Yes. That we
Then?
have to visit. Then your lordship may record my
Convenience for both of us, my lordship.
your lordship may record my objection and lordship may pass orders.
Heard, Mr.
Yes, Vilas.
Learned counsel for the petitioner and Mr. S. Dotto, learned counsel for the respondent. This petition under section 24 of the Code of Civil Procedure is preferred by the petitioner for transfer of TS within bracket divorce case number 129 of 2023 pending before the Court of Learned District Judge Koramganj to the Court of Learned District Judge Hailakandi. Mr. Dotto, Mr. Your good name?
SB Lashkar.
The Learned Counsel for the petitioner submits that the petitioner is a resident of Karimganj. No, Hailakandi. A resident of Hailakandi, where two other cases bearing
MR case number.
number 83, MR case number 83 of 2022 under section 125 and
DV case number.
DV case number 87 of 2022 under section 12, 18, 19, 20, 22 and 18 of the Protection of Women from Domestic Violence Act are pending. And that the respondent is regularly appearing in the aforementioned cases, in connection with the aforementioned cases pending in the Court of Learned Chief Judicial Magistrate Hailakandi. And that the distance between distance from the house of the respondent to the court at Karimganj
29 kilometers. 29 kilometers.
29 kilometer, 29 kilometer, whereas the distance between the house of the respondent to the court at Karimganj or no, to the court at Hailakandi is
38 kilometers. From his house to Hailakandi is 29 kilometers, and from his house to the district court Karimganj is 38 kilometers.
38 kilometer, and whereas the distance between his house to the court at Hailakandi is
29 kilometers.
29 kilometer. And under such circumstances, it is contended that the title suit within bracket divorce number 129 stroke 2023 may be transferred to the Court of Sessions, no, to the Court of District Judge Hailakandi from the Court of District Judge Karimganj. Whereas Mr. Dotto, Learned Counsel for the respondent, referring to a decision of Honorable Supreme Court in the case of Anindita Das versus Srijit Das. Srijit Das has vehemently opposed the petition, and he is agreeable to bear the cost of the petitioner to visit the court at Karimganj, and therefore Mr. Dotto has opposed the petition. Where having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the decision of Honorable Supreme Court in the case of Anindita Das Supra. It appears it is not in dispute that two other cases are pending before the Court of Chief Judicial Magistrate Karimganj, being MR case number 83 of 2022 under section 125 CRPC and DV case number 87 of 2022 under section 12, 18, 19, 20, 22 and 18 of the Protection of Women from Domestic Violence Act. Besides, the distance between the residence of the respondent to the court at Karimganj is 38 kilometers, whereas the distance between the residence of the respondent to the court at Hailakandi is 29 kilometers. Having considered aforementioned aspect, this court is inclined to allow this petition. It is provided that title suit divorce number 129 of 2023, pending before the Court of Learned District Judge Karimganj, stands transferred to the Court of District Judge Hailakandi. The petitioner shall obtain a copy of the certified copy of this order and place the same before the Court of Learned District Judge Karimganj, and on receipt of which the Learned District Judge Karimganj shall transmit the record to the court to the Court of District Judge Hailakandi within a period of 1 week from the date of receipt of the certified copy. In terms of above, this task of petition is disposal.
Obliged.
Okay, number 8.
In this case, I am praying for filing of substantial question of fact, Lordship. Lordship may kindly allow me to file substantial question.
Pardon?
Lordship, substantial question of fact, Lordship. Your Honor may kindly allow
This
me.
IA is for what purpose?
Lordship,
This IA?
this IA is for conversion of this criminal civil revision into second appeal, Lordship.
Volume.
Lordship, in this case, I am praying for filing of your Honor, your Lordship may kindly allow me to file substantial question of fact, Lordship, in this case, Lordship. The case was filed inadvertently in a civil revision petition in the column of civil revision, but it should be in a second appeal, Lordship. That is why your Honor may kindly allow me to file substantial question of fact, Lordship. I am praying before this Honor.
Yes.
My lord, that cannot be done, my lord, because, my lord, although there is no direct provision for conversion, a revision petition into appeal, but under 151 CPC, my lord, in some cases has been done where the revision order appeal is filed within limitation. This is the rider, my lord, there is some judgment. This is the AIR 1978 Allahabad 299, my lord. Here, my lord, this is clarified that if the revision or appeal which is sought to be converted, then if that is filed within limitation, then it can be, my lord, converted. Else, because this limitation, this revision petition is delayed by 633 days. So, my lord, para 4, my lord.
No, the limitation was condoned earlier.
No, my lord. We have strong objection there to they fail to, my lord, we have given our objection there, explain the delay. Here limitation is not condoned. Now pending consideration, this has been filed, IA has been filed conversion. My lord, now if delay is there, kindly see, my lord, para 4. The line started with 5th line, my lord, para 4. This is a discretionary power and is to be exercised provided the circumstances of the case warrant the same. It is also settled, well settled that such an order could be passed provided the appeal or revision had been filed within the time prescribed for filing the appeal or revision, as the case may be. My lord, this is the rider. This is already.
Is there any decision of Supreme Court on this point?
My lord, all the High Court has relied upon this judgment, man. I have charged that Allahabad 1978 judgment is the judgment relied upon by almost all the courts. That if there is
No,
delay.
in several cases, this High Court has also
Yes.
allowed
Yes,
to
Lordship.
convert civil revision petition to.
That's correct, my lord.
In a
Subject to
written,
the condition if revision is filed within limitation. If it is within limitation, my lord, it could have been, my lord.
in a very
Nonetheless, that the pleadings are different. The substantial question has to be there. Proper court fees has to be paid. That's other thing. But now, if revision is still delayed, file delayed, here in this case 632 days. So in such case, let him file, my lord, the proper application, second appeal, my lord.
So
This-
anyway,
This,
Lordship.
in my humble submission, my lord.
Find out the cases where this court has allowed.
Yes.
Lordship, in a very recent case, Lordship,
Hmm.
in a very recent judgment, Honorable Justice Manish Chaudhary
Hmm.
has allowed this repetition into the
But
court.
whether in that case the issue of delay was there or not.
That is important.
Delay part is not mentioned here, Lordship. Lordship may go through the last paragraph of the judgment. And Supreme Court also, Lordship,
1970, AI 1978, Allahabad.
This is regarding this conversion of a writ petition into CRP.
Lordship.
This is,
Lordship. Conversion is allowed, Lordship.
the jurisdiction
By this-
is completely different there, my lord. Under
Repeat it.
226, my lord, lordships knows there's an ample power.
Hmm.
My lord, so far here it is a pure question of CPC, my lord.
Hmm.
Then, my lord, the judgments also says that, my
Hmm.
lord. If, my lord, again, that submission, my lord, para 5, we have already given our, my lord, objection to this petition.
Hmm.
My lord, he can very well file second appeal by explaining delay. But so far, conversion of this present one is concerned. Having 632 days, this conversion, as per this judgment cannot be allowed. By explaining delay, he can file, man.
Can you find out any judgment of Supreme Court on this point? We'll fix a very short date.
Lordship.
Otherwise, you can withdraw this and
He
you can
Yes,
Lordship,
file.
He will get the
is-
time, my lord.
this is an appeal filed by the ASTC, Lordship.
That's
This is a public corporation, Lordship. ASTC.
Maybe the law is applicable.
Lordship, law is applicable to all.
Mm.
That is true, Lordship. That is true. In
Papa-
one of the judgment, that is 1972 4 SCC 168,
Mm.
Honorable Supreme Court has allowed the same, Lordship. That is an appeal filed under Arbitration Act. It's been converted, Lordship. Lordship,
Maybe,
arbitration.
but
Arbitration. This one also. And in a very recent judgment, Lordship, although the judgment is not online, Lordship, I have collected from this one, from the filing section. Honorable Justice Parthiv Jyoti Soikia has also allowed on 2/8/24 in IAC.
that's all right, but whether the issue of jurisdiction, no, issue of delay was there or not,
Lordship.
you see the judgments. Here, this issue of jurisdiction, no, issue of delay.
Limited-
not
pending
here,
limitation,
Not
madam.
here, not here. You examine the matter.
Sure.
We'll fix it on next week. When?
On 17 or 19, as your Lordship feels.
19.
19.
19. As agreed by learned advocates of both sides, SSL raised the matter again on 19. 19.
19. 19. If your Lordship pleases.
19.
19.
Okay. 19. Good. Please, your name, short pass.
Obligation.
10 and 11.
Lordship, they filed a petition for withdrawal. So at the same time, they had filed a annexure wherein a compromise agreement has been annexed. I'll have to take instruction, Lordship.
In this IA,
Right.
heard Mr.
Game over.
Learned counsel for the applicant and Mr. Haloy, learned counsel for the respondent. Mr. Haloy submits that he may be granted 1 week time,
On 16.
16. He may be granted some time to obtain necessary instruction in this regard. Here is accordingly allowed, recessal less the matter on 16.
Publish.
Salim.
So this a compromise agreement was done.
Not sure. Both the parties have compromised on the terms.
Okay.
Salim.
So item 26.
May I please your lordship, as per the order dated 8/2/2024, lordship, we have taken steps, lordship, on 16. But some of the respondents expired, lordship, as per the office note. Respondent number 15, 19, 29, 31, 32, 47. This total 6 numbers of respondents expired, and substitution petition will be filed.
Heard Mr. Sarkar, learned counsel for the appellant and Mr.
I'm for respondent 34. KM Haloy.
Respondent number 34. Your good name?
KM Haloy.
KM Alloy, learned counsel for the respondent number 34 and Mr.
I am 39, madam. 39 year meeting. But my name is soon here 29 against 29, madam. I am appearing for 39. I think
39.
Yes.
AR Medhi, learned counsel for the respondent number 39.
Yes,
But your name is against 29.
29. yes.
39.
My actually.
And
I am
Mr.
appearing for-
Gogo, you were
And 2, 3 and 4.
2, 3 and 4. Mr. Medhi submits that in fact he has been representing respondent number 39, but the registry has reflected his name against the respondent number 29. Accordingly, it is provided that registry shall make necessary correction in this regard. Office note dated order dated 22/5/2024 indicates that notice issued to the respondent number 5, 6, 8 to 12, 15, 18, 18 to 22, 26, 29 to 33, 35, 38, 43 to 48 were issued by registered post with AD. And in respect of notice issued to the respondent number 18, return answer with a report that the address is left. And in respect of respondent number 20 and 21, return with a report that insufficient address. Have you taken a step on this
Lordship.
when?
Lordship, after 3 weeks, Lordship. Respondent number, there not proper address found, Lordship, against respondent number 18, 20, and 21. And on the other hand, Lordship, expired the respondents number 15, 19, 29, 31, 32, and 47. So, in this case, Lordship, we have to file a substitution petition. Those respondents expired.
Notice in respect of respondent number 5. Returned with a report of the process server. And the report of the process server indicates that the notice was received by tenant. Can it be said that notice was served properly?
Cannot be. It is not proper service.
Accordingly, it is provided that learned counsel for the appellant shall take fresh step upon respondent number 18, 20, and 21, and also upon respondent number 5. Notice issued to respondent number 6, 8 to 12, 18, 20 to 22, 26, 30, 33, 35, 38, 43, 44, 45, 46, and 48 have not returned. However, the postal track consignment report indicates that the notices were delivered to the aforesaid respondents. And as such, notice deemed to be served upon the aforementioned respondents. Office note also indicates that but the order of laws in my court also indicates that notice issued to respondent number 15, 19, 29, 31, 32, and 47 returned with a report of the process server, returned answer with a report of the process server that the aforementioned respondents have expired. Mr. Sarkar, learned counsel for the appellant, submits that he will take necessary step for substitution of the legal heirs of the aforementioned respondents and price for granting in 4 weeks' time.
Lordship.
Fair is accordingly allowed. Places shall list the matter after 4 weeks.
I oblige, Lordship.
Oblige.
So items for stay, item number 22.
My lord, I am a-
You for respondent.
Yes, my lord. And there is a stay operating, my suit has been stayed.
Let us fix a short date.
My lord.
None appears for the petitioner on call. However, Mr. Dhar, learned counsel for the respondent present. I'll list the matter next week.
22. Is there, my lord?
Let me tell Lordship.
Ah,
Lordship, this is an application under Article 227 of the Constitution. Lordship.
yes.
Lordship, the responding hearings are filed registered Lordship before the Lordship. Lordship. And the name of the petitioner it is a sole respondent there. The defendant also there. But the name of the petitioner has been wrongly reflected in the service report, Lordship. And also the name of the further is also written there in incorrect Lordship. That is why I did not accept the notice, Lordship, served by the Lordship Transport. Accordingly, the proceeding was a proceeding expert, Lordship. And therefore, Lordship, the petitioner filed an application to order 9 the rule 7 of the
CPC lordship, for setting the expert order lordship, but that was rejected by the London trial court lordship. That is why he is referred to this honorable court lordship.
Where is the MP on order?
Lordship, that is at page 60 lordship.
So you refuse to accept notice?
Lordship, actually, my surname is recorded daddy lordship as Khasi lordship instead of Nidam, and my father's name is reflected daddy lordship as Narayan Khasi instead of the Robert Nidam lordship. That is why he refused to accept the notice lordship issued by the Lordship trial court lordship. Lordship will find the notice lordship at page 48. Annexure 2 lordship. Issued by the London trial court lordship.
So in the summon, both the names are reflected.
Both the names were reflected, but Lordship, my father's name is wrongly reflected, Lordship, as a Narayan Khasi instead of Robert Needham, Lordship. My father's name is Robert Needham, Lordship. Lordship will find the documents, Lordship, that is contains from page 65, Lordship, that is a legacy data, Lordship. At page 66, Lordship, that is, my name is Panna Needham, Lordship, my father's name reflected therein as a Robert Needham. But here in the notice lordship, it is reflected as the Narayan Ghasi lordship. That is why lordship. Sixty-six is the legacy data lordship. And 68 is next of kin certificate lordship. And also my father's name is recorded as Robert Needham lordship. 70 is the pen card lordship of the petition lordship. Therein also lordship my father's name is recorded as Robert Needham lordship. In every document, so actually my father's name is the Robert Needham lordship. Page 74 lordship, the voter list of the 2011 lordship. And therein also lordship, my father's name has been reflected as the Robert Needham lordship. The page 74. Page 76 lordship, that is the Guha certificate lordship issued on 2010 lordship.
Yes, Mr. Dhar.
My lord, first of all, this application has been filed by misleading statement and some suppressing the material facts, my lord. In fact, the trial court before passing the imputed order here has undergone a mini trial to decide this issue, whether an application under order 9 rule 7 can be decided. My lord, if you allow, my lord, take up my affidavit dated 21st of May to 2024. I have annexed, there were as many as 9 witnesses were examined.
9 witnesses.
9 witnesses were examined prior to disposing of this, their application, order 9 rule 7. I'll just carry, prior to that, I'll just show, my lord, this suit was filed, page 30, lordship, of the petition. Suit was filed, page 30 is the plaint against Panna Ghasi, alias Panna Nidham. He writes his name as Panna Nidham also, and his father's name as Narayan Ghasi. Now your lordship will see my prayers, our prayers, page 41. The second declaration, that declaring that the defendant is not the legal heir of late Robert Nidham and he has no right, title, interest and position over the suit land ABCD. And Roman 4, a precept be issued to the circle officer, Jonas Revenue Circle, to cancel the mutation in respect of Schedule A land granted in favor of the defendant, claiming as a legal heir of late Robert Nidham. These are the relief I have claimed. Now, lordship will see the application. Your lordship is seen, he has refused to accept the summons. Now the application, see the application, page 55. The application under order 9 rule 7. Page 55.
So his father's name is Robert Needham.
He claims his father's name as a Robert Needham, and that issue has been substantially decided by the trial court while deciding this Order 9 Rule 7 application. And if your lordship kindly take up the Order 9 Rule 7, it says about a good cause should be shown. Order 9 Rule 7, my lord, may I just merely read?
Yes.
Procedure where defendant appears on a day of adjourned hearing and assigns good cause for previous non-appearance. Where the court has adjourned the hearing of the suit ex parte and the defendant at or before such hearing appears and assigns good cause for the previous non-appearance, he may, upon such terms as the court directs as to cost or otherwise, be heard in answer to the suit as if he had appeared on the day fixed for the appearance. So there should be a good cause for his previous non-appearance. Now,
No, Mr. Dhor, is it not a good cause that his father's name is wrongly mentioned
no,
in
and I will
summons?
show. I will show from the record.
That's all right. You come to this page number 104. The evidence of CW1, the process server.
Yes, my lord.
Para number 3.
Yes, yes, my lord. It is the evidence of court witness number 1.
Yes.
He says he refused to accept the summons, so I went to search in local Latbura, Gaubura. The Gaubura told me this person is Panna Nidham and his father's name is Robert Nidham, and in the summon it is wrongly mentioned. Now, your lordship will kindly come to other witnesses. The court witness number 2, next page, 105. The Gaubura witnesses and page 106, number 7. Para number 106, he says, during my childhood period and after I become adult, I never saw mother and father of Panna Nidham. Then paragraph 9, when I was 10-11 years old, I saw Panna Nidham working in agriculture land belonging to Henry Nidham. That is the other my family. Now I skip. Then the court witness number 3. These are very important witnesses. 107. Here is the petitioner. He says, the question was put to him, question number 2. Why did you file a petition under Order 9 Rule 7 of CPC if you are Panna Nidham, son of Robert Nidham, and not Panna Ghasi, son of Narayan Ghasi? I took the advice of my advocate and I entered my appearance. This was his answer. I will show that there was also a misleading statement. Now, lordship, page 108. This is court witness number 4. His name is Mohan Nidham. He is the brother of Robert Nidham. He says, the first question, how many brothers and sisters do you have and what are their names? John Nidham, now dead. William Nidham, now dead. Henry Nidham, now dead. Thomas Nidham, now dead. David Nidham, now dead. Robert Nidham, now dead. And a sister, Parul, now living. Maggie, Peggy, Bulbul, Putal. Now, question number 4. Name the son and daughter of your father, late F.M. Nidham, and his second wife, Annapurna. Henry, Thomas, Robert, David, and me, that is Joseph. They're brothers, 4 brothers. Page 109, question number 6. Robert Nidham, who is your full blood brother, did he marry anyone? The answer was no. Robert Nidham did not marry anyone. Question number 7. When did Robert Nidham die? Robert Nidham died when he was 13 years old and died of dysentery. Then question number 9. Panna Ghasi alias Panna Nidham claims to be son of Robert Nidham. Answer is, it is false. He is not our relative. He calls me Dodai Dodai and I called him Bhatija. But he is not our relative. This is the own brother of Robert Nidham. He claims father as his father. Now the next one, Kunjalata Nidham from a same family. She is the wife of late Henry Nidham, the brother of the father of this Panna Nidham, he claims. Question number 5. Was Robert married at the time of his death? Page 110, my lord. Robert was studying in Lakhimpur till class 5-6 in a missionary school, and then he was brought to Jonai for schooling and he died. I did not see his wife or kids as he was not married, and he died at a young age. He died at the age of 13 years. The grave of Robert Needham is situated in our land and still present. I skip, my lord. Then 112 put to witness number 6.
So, it is established that he is not the son of Robert.
Robert Needham. Now, the misleading statements made in the British petition itself, my lord. I will take your lordship to paragraph page 11. He says, Roman 7E, sorry, 10E, page 11 of the petition. For that, as your lordship, for that the petitioner had received the certified copy of the plaint of title suit number 3 of 2022 on 24/2/2023. Kindly mark this date, 24th of February 23. And when he gone through the plaint, he was surprised to know that the matter is directly connected to the petitioner. The petitioner is the son of late Robert Needham, respondent herein so and so so and so. So he got the copy of the plaint on 24th of February 2023. Now, your lordship come to page 55. That application 57, page 57. The application under order 9 rule 7 was filed on 22nd of February 2023. So
Page number?
page number 57, the verification of the application under order 9 rule 7. The person who files an application for setting aside an ex parte order under order 9 rule 7, he says that I got this copy of the plaint on 24th of February and files the application under order 9 rule 7 prior to getting of the copy of the certified copy of the plaint. Isn't it a misleading statement? My lord, itself, they have annexed the plaint also, page 29. They have applied on 24th of February. They received the plaint on 24th of February. And prior to getting of this, the statement that they have come to know and obtained a copy of the plaint on 24th, and they have applied for setting aside the ex parte order on 22nd, prior to that. Now, my lord, there are some other things also. My lord, we have also filed an FIR against him.
That is important, Lord. Also, kindly note the Lordship, address of the present petitioner, Lordship.
Page 121 is the translated copy.
Particular at page 25.
There are 2 birth certificates he got. One what he has annexed. We have stated, my lord, they belong to ex-garden T category. They are Anglo-Indian, but he has obtained a OBC certificate of ex-T garden category.
Before producing the contents, Lordship, kindly have a look at the address of the informant as well as the opposite party, Lordship. That is my Lord. My name is written as a partner Needham, Lordship, son of late Robert Needham.
But we have alleged that he is not
filed by Ibrahim, Lordship, with the court witness number, Lordship.
Now, your lordship will find the birth certificate which we have annexed. Page 129, my lord. It's a type copy of, and the original copy, Xerox copy 130. Here the date of birth of the petitioner is 10/3/1976. And
Where it is mentioned, page number?
page 129.
Yes.
Here the date of birth is 10 March 1976. And annexure 8 of the petition filed by the petitioner, they have also annexed another birth certificate, page 67.
Page number?
Page 67. Well, when somebody manufactures some documents, it always difficult to match the other things. Page 67, date of birth, your lordship has seen 7/5/1971. Now page 68, my lord. That is the next of kin certificate the petitioner obtained.
Which one is earlier?
My lord, if
relying on lordship the
if these
72.
two birth certificates are taken, then the petitioner born only my lord, prior to his father, after the death of his father.
But his father was not married.
That all the plaintiffs say he was not married. Now these documents which have been annexed, from these documents itself, if I'll show, because page 68, this is the next of kin certificate.
And there is discrepancy in respect of the date also.
Yes, sir. Yes, my lord.
Date of birth and age.
Hmm?
Date of birth and age.
Date of
Some
birth and age.
discrepancies are there, but
Hmm.
I'm
He
relying on-
claims his father.
Why you have obtained two birth certificate?
Lordship, I have only one lordship, that is the annexure 67. Now they are relying on another one lordship. I don't know, I have no knowledge lordship.
Hmm?
I am showing from, I will show from his document, whatever he has annexed to this petition, that all these discrepancies are there. The next of kin
No,
certificate.
this 129, is it his document?
One document I
129,
have
the
annexed.
second birth certificate.
I have obtained this birth
I
certificate
don't know where from
With-
I got it, lordship.
in the name of the petitioner.
When?
My lord,
When you have obtained?
from the office of the health services, my lord.
Acha.
And here the date of birth is 1970. The birth of year is 1976.
Hmm.
My lord will see the Aadhaar card. If we take his birth certificate, which he has annexed as correct, then the Aadhaar card annex is, my lord, annexure 12,
Page number?
page number, my lord. Page number 72. If we take his birth certificate, which he has annexed, is correct, then the Aadhaar card, my lord, he has annexed as annexure 12 at page 72. The date of birth is something else.
Where it is mentioned?
My lord, the Aadhaar card, lordship
Yes.
has got
Yes.
date of birth, DOB, 1st January 1972.
Yes.
And as per his birth certificate, is 7/5/1971. what the birth certificate he has annexed. From his own documents, I'm showing there are discrepancy in that. Now, your lordship, the next of kin certificate, page 68. There also some discrepancy is there. This certificate was obtained in the year 2020 when his age was shown to be as 48 years old. In 2020, he was 48 years old, and the application in the verification of the application under order 9 rule 7, his age has been shown to be 53 years, which was filed in 2023. And page 52. I'm sorry, madam. And the voter list which he has annexed, page 73. It's a voter list of 2010.
So anyway, as per the inquiry conducted by the learned trial court, he is not the son of Robert Needham.
Robert Needham. And if he is not Robert Needham, so son of not Robert Needham, why he has claimed, and no reason at all is given for filing this application under order 9 rule 7. My lord, this court is on several occasions has observed that then an application under order 9 rule 7 should not be decided as a routine affair. Otherwise, everyone will first refuse to accept the summons, and later on came, oh, earlier I have refused. Now I want to vacate the order of ex parte order and let me contest the suit. And this suit is at the stage of cross of PWs. They are given an opportunity to cross-examine the plaintiff witnesses. Now, my lord, so this application, this order, even passed by the learned trial court, does not even suffer from any any patent illegalities warranting interference of this honorable court under 227 article 227. My lord. So, I mean, my humble, this learned trial court also observed that CW4, CW5, CW6, CW7, and CW has stated that the petitioner is not Panna Needham, but Panna Ghasi, and not from their family.
CW1?
CW4, page 63, my lord.
1, 4?
CW4, CW5, CW6, CW7, and 8.
Yes, any reply, Mr. Gogol?
Yes, sir, Lordship. So for the photo is number 428, Lordship, and here the plaintiff of the plaintiff, Lordship. They denied it my father. The claim, as a claim by the present petitioner, that Robert Needham is my father, Lordship. All are denied, Lordship. That is true, Lordship. Lordship, kindly have a look at the page 125 of the affidavit of opposition filed by the respondent, Lordship. He has very technically avoided that part, Lordship. Lordship, 125 one is the Barney Lordship. Of their affidavit of opposition, Lordship.
Yes.
Yes, Lordship. First, it Maloney Lordship, Zona Rokitana, Professor so Bikoy Azahar, Ibrahim Needham. Ibrahim Needham is a plaintiff number 5 of the title suit, Lordship. My name is reflected in the upper vocal, Lordship. Panna Needham, Peter Surga Robert Needham, Niba Eknong, Murkong Select, Hana Zunai, Nemazi, Lordship. It was lost by the plaintiff number 5, Lordship, in the year of 2020. 23. 21, Lordship. While they gave their deposition, Lordship, they denied that Robert Needham was my father, Lordship.
That was our allegation, my lord. If we read the entire
That is
FIR,
the thing, Lord.
if we read the entire FIR, if your lordship permit,
If I am not the son of let Robert Needham, Lordship, then
I,
why
I,
this
I
is
can read the
given
transcripted
the
copy.
address, Lordship?
This is the only
Affidavit,
to
sir.
identify.
No,
Sir, dear Lordship, regarding the age,
this
Lordship.
this document cannot read as a testament that you are the son of Robert Needham.
It was lost by the plaintiff, Lordship. Plaintiff number 5. If I am not the son of the Robert Needham, Lordship, why they stated there, Lordship? That is a big question, Lordship. Is the plaintiff number 5, Lordship, the title, sir?
So the other family members have categorically stated that Robert Needham was not married.
So this
He
is
died
away
in
from the
13
inheritance of my ancestral property, Lordship. Intentionally. Otherwise, Lordship, a process server, Lordship. Well, have a look at again, Lordship, the report of the process server, Lordship. At page 50, Lordship. Particular, Lordship. In Congo also says that Robert Needham was the father of the papers and petitioner, Lordship. সন্মানপূৰ্ণভাৱে জনাওক যে ইংৰাজী 10-11-22 তাৰিখে এই চমন দিবলৈ যোৱা হয়। চমনত উল্লেখিত ঠিকনাত গৈ চমনৰ নাম থকা ব্যক্তিজনক চমন দিব বিচৰা তেখেতে নামৰ সৈতে উপাধিৰ মিল নাই আৰু পিতৃৰ নামৰ মিল নাই বুলি চমন ল'বলৈ অস্বীকাৰ কৰে। তেখেতে মৌখিকভাৱে জনায় যে তেওঁৰ নাম উল্লেখিত ধৰণে পান্না ঘাচি ওৰফে পান্না নিধন নহয় আৰু স্বৰ্গীয় নাৰায়ণ ঘাচি পিতৃৰ নাম নহয়, তেওঁৰ নাম পান্না নিধমে হ'ব লাগে বুলি তেওঁ কয়। এই বিষয়ে স্থানীয় লাট গাঁওবুঢ়াক সোধপোছ কৰাত তেখেতে লিখিতভাৱে জনায় যে চমনৰ উল্লেখিত ঠিকনাটো ঠিকনাত কোনো ধৰণৰ ব্যক্তি নাই, কিন্তু পান্না নিধম পিতা স্বৰ্গীয় ৰবাৰ্ট নিধম নামৰ এজন ব্যক্তি আছে আৰু that is also there. That is the report of the process server.
And even if it is there, we have made party Panna Ghasi as a alias Panna Nidham, son of Narayan Ghasi. If he is not that, he is the son of Robert Nidham, he should not have filed this order 917 application. One, he is denying that I am not Panna Ghasi, alias Panna Nidham. I am not this, my father's name is not Narayan Ghasi. But again, he files an application saying that yes, I am Panna Nidham, I am son of Robert Nidham. That is what the trial court has observed. Madam, page 63. At one point of time, a person refuses to accept summons. At another point of time, he files petition under Order 9 Luke 7, page 63. That he is not defendant. At another point of time, he files a petition under Order 9 Luke 7 and calls himself defendant, which is earlier at the time of service of summons stated that he is not the defendant. Such is the conduct of the petitioner in petition number 17 of 2023. And my lord, the lordship has seen that the requirements of Order 9 Rule 7 has not been complied with while filing the present application under Order 9.
Part Mr. B.K. Gogoi, learned counsel for the petitioner, and Mr. A. Dhar, learned counsel for the respondent. Order is that.
My lord, two judgments, I just.
You can participate.
My lords, obliged.
I've taken consent from the other side, madam. Can it be taken up next week, madam? I have some difficulty. 1-6. Next week, madam.
Okay. On the pair being made by Mr. You are for respondent?
I am for respondent.
P.K. Roychodore, learned counsel for the respondent. With consent from the other side, raises a list the matter on. When?
Next week, madam.
Next week. Next.
Obliged.
Item number 23. 23 is the matter.
May it please your lordship, we have taken steps from the respondent. Respondent number 2 has appeared. The respondent number one, we have taken steps. While doing dusty, we did not locate the respondent number one. Lordship, we have taken the same address that is given by the, that was given in the civil judge, page number 48.
Page number?
48.
No, it appears that a notice is yet to be served.
We have gone to the place, but we did not find respondent number one to trustee service.
Then you find out the proper address.
The address which was given by the applicant, by the respondent number one in the court of civil judge Noga, we have taken the same address, but we could not find.
Then what to do? Anyway, you have to call service of notice. Heard miss, your good name? A. Khetawat, learned counsel for the petitioner. Office note dated 2/9/2024 indicates that one Okalatnama has been filed by one learned counsel on behalf of the respondent number 2. However, notice issued to the respondent number 1 returned with a report with postal endorsement with an inverted comma insufficient address. And the notice issued to the respondent number 1 by usual process is yet to be returned. Whether dusty service was permitted?
Yes.
Affidavit pertaining to dusty service also yet to be filed. Under the above mentioned facts and circumstances, it is provided that learned counsel for the petitioner shall take fresh step upon respondent number 1 after obtaining proper instruction in respect of the address by usual mode and also by registered post with AD within a week from today. List the matter after 4 weeks. Till then, interim order pass earlier shall continue.
Item number 27 upgraded. Ordered matter for hearing.
What date? What date? Yes.
May I please?
Hmm.
On last occasion, let's say we have started reading para 23-24
Hmm.
of the plain page 44. From here, we have to stop because of the times.
Hmm.
Para 24, 20, 23, 24,
Hmm.
25, 26, and 27. These are regarding cause of action and the statements that property belongs to the parents and thereafter after death, petitioners presently become the owner along with defendant number 1 to 4. Para 23 have specifically stated that the plaintiff number 3 daughter of late Suti Miki, who was also one of the scheduled B land, and Sutiram Miki died leaving 4 daughters, namely Iman, and entitled to 1/4 share of the total income of rupees 75,000 out of rupees total income of rupees 3 lakhs. And Sutiram Miki left 4 daughters, and 4 daughters are equally entitled to rupees 75,000. Plaintiff number 3 also entitled to 1/4 share. And accordingly, plaintiff has claimed rupees 4,50,000 and defendant number with effect from 1/7/2011 to 36/2013. She also demanded from the defendant for payment of the said amount on 1/6/2003, but defendant refused to pay the amount. These are the affirmance. Now I'll take a look at page 144. That is the reply given. Page 144. Para 13. The statements made in paragraph number 25, 26 of the plain are not correct. These answering defendant strongly deny the same. In this connection, this answering defendant begs to state that since date of purchase, Rice Kerapani has been specifically peacefully possessing the same without disturbance from any corner. Since few years back, Rice Kerapani have constituted committee, the Kerapani Gao Undayan Committee, and said committee is led by defendant number 8 and 9. Rice for Kerapani through secretary and president of the said committee is running the market over the suit peacefully. And by outcome of the said market, defendant number 8 and 9 is developing the area and also doing development works of the Bodo Ram Rangshan Pathamik Vidyalaya and also looking after the welfare of the Mahila Committee. Standing over the suit land, and suit land is not suit land is not personal or individual property of the father of the plaintiff, and land in question is absolute property of the Rice Kerapani, and Rice through defendant number 7 is peacefully possessing the same right, title, and interest over the suit land and possession, and appointing a receiver does not arise at all. Suit has been filed only to give in unnecessary harassment to the defendant as well as general people of the Kerapani and plaintiff have no locus standi upon the suit, and the question of collection of area rent from the traders market stand near suit does not arise at all, as such suit is liable to be dismissed with compensatory cost. And regarding cause of action, Lordship will find that there is no cause of action of the suit and absolutely incorrect, and cause of action arose on 1/7/2000 as mentioned in paragraph 27 of the plain. Regarding this, Lordship, I have already stated, made a submission that denial of a statement should be specific. I have given a judgment on this point. Lordship will find the judgment. Lordship will find the judgment of the Supreme Court, that is 2022 1 SSC 115.
In this bundle?
2022.
No, in this bundle.
Lordship, I think it will be better for giving a submission and relevant judgment of the Supreme Court.
Yes.
That will be better for you, Lordship, to my placing. Lordship got it. 2022 1 SSC 115.
2022
1 SSC 115.
Option 22 7 SSC is there.
2022 1 SSC 115. I've given the set, Lordship, total judgment set.
Acha, okay. Uh-huh.
By Justice Sanjay Kumar Kaul and M. Sundar.
Yes, got it.
Now I take your lordship.
This is in respect of cause of action.
Cause of action as well as the denial should be specific. Cause of action and denial should be specific.
Yes.
Lordship will find page 4. Para 20.
Yes.
Lordship, may I read?
Hmm.
Order 6 quote, while defining the word pleading, make it applicable on even terms, both plain and written statement. Even pleading Order 6 Rule 2 shall contain a statement of material facts which the party relies either for his claim or defense. Such pleading should contain necessary foundation for raising an appropriate issue. Under Order 8 Rule 2, a defendant shall make a specific pleading, while under Rule 3, a denial should be specific. That is very important. Rule 4 prohibits evasive denial, and Rule 5 speaks consequence and not denying specifically an averment in a plain, leading to a presumption of an admission. So my submission will be, Lordship, we have made a specific statement regarding cause of action. They have stated what they have stated? Denied. What we have stated in paragraph number 22 regarding our share, regarding our entitlement, they have not stated anything. They said that land belonged to Rice Goiro and Rice Goiro is to collect the revenue from other person. We have made a specific statement that with effect from 1/7/2011, they have refused to, did not allow to us to collect the rent. They have not stated anything. They have stated that it is not correct. Only that statement, fact statement. That is evasive denial. Evasive denial means admission. May I read again para 24? That plaintiff are getting the single footing from the collection of rent from Schedule B land with effect from 1/7/2011. Earlier till 1/7/2011, plaintiff repeatedly requested the defendant to give their share and allow them to collect the rent from the market to the extent of their share as they used to collect earlier till 36/2011. But defendant forcibly illegally debarred the plaintiff from collecting the rent from the market, which was set up by himself in 2006. So there is no denial to that effect that since 36/2011, we have been not allowed to collect the rent. So evasive denial means admission. They should deny that it is not correct that up to 36/2011 they are collecting the rent. There is no denial to that. We have made a specific statement. Para 25. It is pertinent to mention here that petitioner and the land had continued to possess the land jointly. After death of 3 purchasers, their legal heirs also continued to possess the scheduled land jointly. And land has not been divided among co-sharer by myth and bounds till date. Plaintiff are still in occupation of the land. Plaintiff number 3 had got one shop in the market. She himself used to run the shop, but due to personal difficulties, he gave up the business in the month of November 2010. What is the denial, Lordship? I have pointed out page 144. There is no denial at all. It is not correct. That is an evasive denial. Evasive denial means admission. So my submission will be the denial made in para 13 is 144 is an evasive denial.
You're not sure it's purchase or not, plaintiff is not there. Para 25 is referring to plaintiff. It's purchases of. So there is difference between purchase and plaintiff here. Taking purchase and plaintiff, written for purchase.
Secondly, Lordship, we have said right title and interest of the title of 20 of Schedule B land have been clouded on account of judgment of Revenue Board. Lordship, Revenue Board has declared title of the plaintiff, defendant. That is the Kepinizal. That is the defendant, Lordship, defendant number 7. Lordship, I'll give a judgment on these points. Every submission will be supported by a judgment of the Supreme Court, which Supreme Court has categorically stated that that is a division bench judgment of this honorable court. That is by Justice
A. Rokubur and W.H. Shishat. Where the Supreme Court, where the division bench of this court has categorically stated,
Citation, please.
1990 1 GLJ 304.
1990.
1 GLJ 304. That is a division bench judgment. Lordship, this short judgment. Lordship may underline the paragraph, Lordship, that will be better. Last but one, Lordship. Revenue authorities do not have power to decide question of title. Lordship, title, it is obvious from a reading of section 41 of the Act, when title is relevant, revenue authorities are to refer the party to a civil court. This is the scope of section 41 of the Act. Never let question title prevail in the order of the authorities. Assistant settlement officer, and board of revenue have power to consider position, and position alone can be determined. When the issue as to title arise, authority have no jurisdiction to decide such issue, and parties have to be referred to the civil court. So the authority that the board of revenue has determined title, interpreting the clauses of the title, that cannot be lodged. And one point of the argument of the defendant was that we have claimed relief in favor of the defendant also in our suit. That cannot be obtained by us without taking leave from this honorable court. That was their submission. Initial submission was then. I will place a judgment to that effect. Last occasion, so they are insisting for that. I'll produce the judgment. And Lordship will find what relief has been granted to us. May I read the judgment at page 15, last portion, page 32. Judgment page 26. Page 26 is the judgment of the trial court.
Which issue?
Page 26, Lordship.
Which is the issue?
In the order or judgment of the trial court, which is under silence in this appeal.
No, that's all right.
Suit is decreed on contest with cost. Right, title, and interest of the plaintiff in respect of the suit land is described in Schedule B, hereby declared jointly. They are saying that joint right cannot be declared by the trial court. That is their prayer. Submission, not prayer, Lordship, this is submission. Because my right has been declared along with defendant number 126. Lordship, I have made a categorical submission on last occasion that 4 brothers of a family, if one brother is entitled for share, he can claim right 1/4 share of the land.
Your Lordship, these are not brothers. That's why I'm reading. They are not brothers.
You can make
They are
it like
they are all 4 separate persons here. That's why the confusion with having the same title. They are 4 different individuals of the village.
I am not
They are
interfering.
not. They are not brothers.
I am not interfering with his argument.
Mr. Sodore, okay,
Yes,
you
that's
will
why
got an opportunity
Yes.
to.
No, I'm just clarifying the thing. Because that is
If he want to argue again, Lordship, I have no option, but he can argue.
clearing the confusion.
I have nothing to show.
He said
nothing to say.
brothers, it's not brothers there. That's a clear.
Let him complete first.
No.
Thereafter, you will get opportunity.
I'm giving a judgment to this effect, Lordship, regarding declaration of right title of the co-sharer. (2014) 1 GLJ 545. Now para 34.
Para
34. From para 33 onwards, it will be better, Lordship, I read. From the evidence on record, there is nothing to show that plaintiff had in any manner declared, acted, omitted to permitted the defendant to believe the thing to be true and act upon such belief. Plaintiff failure to mention in the plain that his brother was also entitled to 1/2 share of the suit land does not attract provision of section 115 of the Evidence Act. Therefore, trial judge committed an error by holding that the suit is hid by principle of estoppel. As such, First Appellate Court rightly reversed the said decision of the trial court. From my above discussion, it is found that co-sharer alone can bring an action. That is very important. Co-sharer can bring an action for declaration of title and every position against the trespasser for the benefit of the co-sharer. This line is very important. I am the co-sharer of the land and I can file a suit for, these are the trespasser, they want to occupy your land, we can bring a suit. Can bring a action for declaration of title and position against the trespasser for benefit of the co-sharer. As such, suit cannot be to be bad for non-gender of co-sharer because of the decree passed in favor of the one of the co-sharer against the trespasser does not take any right of the other co-sharer. So it is limited to the Lordship. It is found that co-sharer alone can bring an action for declaration of title and position against trespasser. That is, full stop maybe in that, Lordship. We are not claiming any relief against defendant number 1 to 4. Joint right. And there is another judgment to that effect.
No, not necessary to multiply it as this is. Yes.
There is another judgment. I'm not reading the judgment, but I'm giving a reference. That is, Lordship, 2018 3 GLT 562, where para 6, Lordship may note it down.
3 GLT.
This page 562. Para 6, wherein joint declaration was given. That was para 6, Lordship.
Citation?
Citation 2018 3 GLT 562. Para 6, where this court has not interfered, declaration of joint right along with the plaintiff. This court has para 6. Now I take your Lordship to the written statement filed by the defendant who are the co-sharer of the land. Lordship will find written statement of defendant number 1 and 2 at page 126. Page 125 also of the appeal memo.
Yes.
May I take your Lordship to the para 7. Page 126. Lordship got it. I'm not reading the whole paragraph, I'm reading the 11th portion. It is further submitted that general people of the area cannot claim the right over the suit land, and no name has been mutated Raj Goirao in respect of the disputed land. Title and position of the suit land has not at all been decided. Mere observation made by the Assam Board of Revenue Guwahati, RA 160 did not confer any title, absolute title over the suit land in the name of Raj Goirao, which alleged to have been represented by Khera Penijal Gaon Panchayat Committee, who have no locus to represent the suit land on behalf of the rise. Lordship, in this particular case, may I submit one thing, another thing, Lordship may take it consideration. There is no any independent witness from the rise. That means only the society is represented and evidence is given by the member of the society, secretary and the members. No one from outside of the Gaon village has examined as a witness. That money has been given by the people of the locality for purchasing in 1957. Now, Lordship, para 9, With regard to statements in paragraph 13 of the plain answering defendant beg to submit that answering defendant are the legal heir of Chutiram Mikir and Kantiram Mikir, and being legal heir of Chutiram Mikir and late Kantiram making answering defendant are also equal footing with the plaintiff. It is submitted that the plaintiff being legal heirs of Chutiram Mikir and Kantiram making heavy right to get rent equal proportion to the share of being holding whatever collection is made from the bazaar as rent paid by the each people. Plaintiff also entitled to equal proportion of the share along with the answered defendant. So they have admitted that they have also equal right with the plaintiff. Similarly, Lordship will find the written statement of the defendant number 3 at page 131. Page 131, middle portion. That read whole paragraph, you will take waste of time. Page 131, middle portion. Land was never purchased by the purchaser on behalf of the villagers of Khepinijal. If the land was purchased on behalf of the villagers, land would not be mutated in the name of the individual person. But no objection was ever raised at such contents of the same defendant. The land was purchased on behalf of the rise is totally false and baseless. And it is after
You are reading para number 2.
Para number 2, middle portion.
Page number
131, page 131.
Yes.
The land was never purchased by the purchaser on behalf of the villagers of Khepinijal. Lordship, what?
No.
Page 132, Lordship, then. There is a difference of paging, Lordship, 132.
Oh, yes. 132.
Lordship, their page mark is difference.
Yes.
Second, para 4. It is further submitted, para 4, last second paragraph. It is further submitted that the general people of the area cannot claim any right over the suit land. No name was originally muted in the rights in respect of the disputed land. Title and position of the suit land has not at all been decided. Mere observation made by the Assam Board of Revenue Guwahati does not confer any absolute title over the suit land in name of Rice Goyro, which alleged to have been represented by Khepinijal Gaon Unnayan Samiti, who have no locus to the present suit land on behalf of the rights. So they also supporting the claim of the plaintiff. Though they are made defendant, because we have to make all the co-sharer as defendant. That is why they have appeared. They have admitted our claim along with them. And that is why trial court has declared the suit jointly. Now, dear WS at page 137, Lordship, can you see page 137?
Yes.
Now, in the written statement, Lordship is aware that is admitted position. Every submission should be supported by pleading. Their initial submission, Lordship will find that their written statement, they have stated that suit is not maintainable on the ground that they are claiming relief against in favor of the defendant 1 to 4. Where is the averment, Lordship? There is no averment that suit is not maintainable because we are claiming joint title and interest. There is nothing on the record. There is no statement in the WS 4, 2, 5, 6, 7, and 11 who are the now appellant here. Nothing has been stated that suit is not maintainable because you are claiming relief against it as well as for the defendant number 1 to 4, 1 to 3. And page 159, one evidence I want to read. What is supported our case? That is page 159, Lordship, got it? That is the logic cross exam DW1 Nolini Mikir. The suit land is a 9 biga 4 kata 81 lesser. Suit land is apparent from the exhibit co was purchased by Sutiram Mikir, Kantiram Mikir, Boloram Mikir, and John Mikir. It is also apparent that exhibit co that seller of the Hiren Rampukon and Biren Rampukon executed the same on behalf of the Raj, villager of the village Karapani village. It is apparent from the exhibit co that Hiren Rampukon and Biren Rampukon on behalf of the villagers of Kherapani suit land in favor of the purchaser stated herein below. As per exhibit co, exhibit 8, there is no mutation in the name of Sutiram Mikir. Purchaser never mutated in the name of the suit land. Name of the plaintiff were never mutated in the records of suit land. It is not a fact that name of the plaintiff were mutated. Height order dated 12/7 in miss case number Iman is settlement officer. Against that order, Lordship, they have filed the appeal before the Board of Revenue. And Board of Revenue has decided, Lordship, I'll take it to Board of Revenue's order. Again, how Board of Revenue has decided, Lordship will find at page 238.
No, on the other day, you have pointed it out.
It is pointed out, Lordship.
Ah,
Lordship, pointed out.
okay.
And one thing I again reiterate, Lordship. What is the finding? It is presumed that the word rise goira should have been before the word barabar in the sale deed. It is presumed. Where is right of presumption, Lordship? Presumption is, Lordship is aware, 113 of the Evidence Act started the presumption. Court can presume certain facts. Regarding dowry, that another thing, there is a presumption. Lordship is aware. 113, another thing is Evidence Act. But there is no presumption regarding interpretation of the CPC. Really, Lordship, the document should be read as a whole. There is no presumption in favor of any court except 113 and onwards in the Evidence Act. Lordship is aware, because dowry debt, there is a presumption. In case of Lordship, the presumption, Prevention of Corruption Act, there is a presumption. Otherwise, there is no presumption. Lordship, brief of the case is like this, Lordship. I do not like to extend the matter to large extent. Only thing is, main dispute is they have no title deed in their favor. They have obtained the mutation in their favor after Revenue Board's order. They have obtained a patta after a Revenue Board order. They have no document to establish that title has been transferred in their favor. And this society has established after 2008. I have already produced the registration deed. There is no evidence that the villagers has paid the money for purchase of the land. That is, there is no evidence. Nothing, no one has stated that money has been collected by the villagers for payment to the vendor. Secondly, Lordship will find, I have already pointed out that point of reservation on the first occasion I have given a judgment. Now I place already I have given the 2 judgment. Next 2 judgment I will give. Power of Appellate Court. That is 2022 1 SCC 115. Para 5. 1 SCC 115. 2022 1 SCC 115.
2000?
Lordship was already pointed out. The denied should be specific. That is the judgment. 2022 1 SCC 115, where at page 5, Power of Appellate Court has been stated that everything should be decided on the basis of the pleadings. When there is no pleadings, they cannot argue upon the appellate stage.
Paragraph number?
Page 5, that is paragraph number. Paragraph number, it starts from page para 20, 21, 22, 27, 22.
The judgment referred today.
Lordship.
Okay.
Next portion is this, Lordship. If I read all these things, it will take time, Lordship. I will not waste your Lordship time.
Okay.
Second judgment on this point is, Lordship, any argument should be on the basis of what has been stated in the pleadings. In the written statement, as well as in plain. Plain should be read as a whole regarding relief claim. That is Lordship 2007 SCC 215 para 7. I have already given the copy, Lordship.
2007.
2007 SCC,
Acha, okay.
page 81. 2007 SCC 215, sorry, I'm sorry. 2007 SCC 215, para 7. And Lordship, the regarding consequential alternative relief, alternative relief, that is Lordship 2014 4 GLT 349.
2014.
4 GLT 349.
2000.
2014 4 GLT 349. Para 16. Lordship, in merit is important. What we have stated, we are in possession of the land up to 2013, and thereafter my one shop room is there. I am running this shop. That is why Supreme Court has stated this, that as discussed above, if the plaintiff's claim to be in possession and his position is found to be found by court, his suit for declaration of right title interest cannot be dismissed for not claiming decree for confirmation of possession. And regarding Lordship, the consequential relief and declaration of right, 1975 to SCC 530, I have given the judgment also. Para 7, 8, and 9. 1975 to SCC 530.
Consequential relief, you have already referred.
Already
another
referred one
judgment.
judgment. This is additional. Para 7, 8, and 9. Regarding sale deed, Lordship, already I have given a judgment. When recital is, Lordship, dispute recital should be, and the surrounding circumstances should be read. Otherwise, court has no power to interpret. I am not giving the judgment, Lordship, now again. Regarding Lordship, recital of the sale deed, regarding Rice Goiro, Lordship has already, I think, noted it down. 2009 4 SCC 193. Regarding recital of the sale deed. That is the moot question.
2000.
2009 4 SCC 193, para 19.
Page number?
Page number 193. 2009 4 SCC 193.
Paragraph number?
Paragraph number 19. That is the moot question also. And secondly, Lordship, these sale deed executed in favor of the purchaser at the plaintiff herein, as well as defendant number 1, 2, 3, has not been challenged by any suit or declaration that sale deed has been void because they have no right, they have purchased the land on behalf of the rights. And that is why Supreme Court has categorically held in 2019 3 SCC 745 para 42. 2019 3 SCC 745 para 43.
445.
745. Para 43. Transfer by registered instrument cannot be held to be void unless it contravenes any law, which is not the case of the appellant society. Here also, there is no appellant society, that is a registered society. There is nothing on record that it contravenes any provision of the law. It can be declared void. The sale deed can be declared void that it was purchased in your society. Then they have to show contravention of any law. Otherwise, it cannot be declared as void. That we are the owner of the land. And Lordship, we have produced the title deed. And subsequently, after revenue board order, they have making all these documents regarding holding number and everything. I have already shown this.
Okay, any other point?
Lordship, I think this is not required. Regarding joint position, there is another judgment of this
No,
court.
no, not
required.
necessary. Not necessary.
That is also by this court, by single bench. So my submission is basically, Lordship, what they have produced, the documents. These are after Board of Revenue order. And Board of Revenue order was challenged before the High Court. High Court has specifically recorded that any order passed by the Board of Revenue in consequence of the Board of Revenue at page 1 to 26.
On the other day, you have pointed it out.
Lordship, that is why I'm repeating only things that for repetition, I'm saying that already division Guwahati High Court in the judgment, which is under challenge, Board of Revenue, court has held, it is subject to the decision of civil court. So this is my sum and substance, Lordship.
But the one thing you have not submitted, although they have not, the other side has not pointed it out or argued on the what would be the point for determination in this appeal?
No, I have already, last occasion I have submitted. Point for determination is, they have said suit is barred by limitation. That is first point. Last occasion I have pointed out also. Their argument, point for determination is, their initial argument is suit is barred by limitation because land has been purchased in 1957. They are claiming right in 2016. That is the first point.
So one point is limitation.
One point is first initial portion is limitation. Second question is no consequence relief has been claimed. Third point is relief cannot be claimed for defendant number 1 to 4. That is joint owner.
Defendant's number?
Fourth is relief cannot be claimed for defendant number 1 to 3.
1 to
3. 1 to 6.
Next point.
Next point is they have said they have the patta in their favor. That is of 2000 after Board of Revenue order. These are the points they have argued mainly. If anything left out, they can point out also.
Okay.
And second question, my submission will be going to be determined whether the sale deed, which has been marked as exhibit O, can confer title of Khepinijal Committee. Defendant number 7. Whether exhibit Co can declare right title interest of the Khepinijal Society or in favor of the plaintiff.
Exhibit Co.
Whether by exhibit Co they can claim right about the property. Appellant can claim right about the property. That is a sale deed. That is not under dispute.
Yes.
These are the points, Lordship.
Okay.
Lordship, if any against my submission, I will not give reply. But anything new submission is made, I can give the reply. If new point is raised, if any new point is raised, except this, Lordship.
No, definitely he will not raise any new plea.
Lordship, I do not think.
He will reply to the submission made by you. Yes, Mr. Soduri.
Since my learned friend has hammered on the Board of Revenue thing, I start with that all documents, Your Lordship, which is nullify everything, Your Lordship. Your Lordship will take to page 2 to 4, exhibit job. This affidavit was filed by plaintiff number 3 and defendant number 1, Your Lordship. It's very important.
Page number?
Page number 2 to 4, exhibit job. It's an exhibit. I read that, Your Lordship.
2 to 4, yes.
This is this Jonaki Mikir is plaintiff number 3 and Senu Mikir is defendant number 1, Your Lordship. Your Lordship, note that. Here, Your Lordship will see that our father Suti Mikir, along with other person, namely Boloram Mikir, Kantiram Mikir, and John Mikir, were respected people of village of Khepanejal. Now, para 3 is very important, Your Lordship. This is a plaintiff has stated, plaintiff number 1 and defendant number 2, for whom they are pleading. That we have come to know that Khepanejal rise by contribution of rise. This is important. On 13/3/1953, our father Sutiram Mikir, along with Boloram Mikir, Kantiram Mikir, John Mikir, as Raj Greha, had purchased from Hirenram Phukon and Birenram Phukon, resident of Borolugu, a plot of land measuring 9 biga 4 kata 1 letha of dark number 1012 KP Patana so and so village Khepanejal Moja by registered sale deed. Number so and so. Since the date of purchase, the rise of Khepanejal has been possessing the land by occupying the same and at present also occupying the same. At present, patta number land 77 need dark number so and so. Then you Lordship come to para 5. That we have come to know that by reading of the sale deed 13/3 that the said land is not the individual property of our father Sutiram Mikir along with Boloram Mikir, Kantiram Mikir and John Mikir. Plaintiff number 1 and 2 are the son of John Mikir, Your Lordship. Since Rise of Khepanejal has purchased the land as Rajgraya, in the said land, waris of Sutiram Mikir, Boloram Mikir, Kantiram and John Mikir will have no rights. This is very important. This is their own statement. Then if Your Lordship will see, be it mentioned that filing that we have not seen the deed so and so 30 land purchased by Sutiram Mikir, Boloram Mikir and John Mikir. So we have filed mutation case. They say, now we are fully aware that land purchased by right of Khepanejal as such, we have no right along with the waris of Boloram Mikir, Sutiram Mikir, Kantiram and John Mikir. So the mutation may be granted in favor of President Secretary Khepanejal and said dispute in future, Your Lordship. The next page, Your Lordship. We state that we have not filed any case against the order dated 1972 passed by the Assam Board of Revenue. Since we came to know that our father Sutiram Mikir, Boloram Mikir, Kantiram Mikir, John Mikir purchased the said land at Rajgraya in the name of people of Khepanejal, and since the date of the purchase, Your Lordship will see, the land is under a peaceful possession of the village people. Admitted, Your Lordship. So you pray the land record may be corrected in the name of Khepanejal so that nobody claims individual right. So this is one affidavit, Your Lordship. Then the next affidavit is again by these people, Your Lordship. that is, if your lordships go to exhibit job. This is
Page number.
Your lordship, page number is 233. This has been filed before the Board of Revenue by defendant number 2 and 3. Soben Mikir, who has deposed in their favor, has stated a contrary stand here, your lordship. That your lordship will see. Para 2, that on, my lord has got it.
Got it.
That on scrutiny of the registered deed of sale bearing number so and so, that we have now come to know that our father Kantiram Mikir along with Sutiram Mikir, Boloram Mikir, John Mikir in Rise Goria of village so and so, Beltola has purchased a plot of the measuring so and so. Under the from Birendram Pukon, and since the date of purchase, the Rise Goria of Kedar Rise has been peacefully possessing the same without any disturbance from any corner, and the land in question is not the own land of our father, as well as not of our own land of Sutiram Mikir, Boloram Mikir, and John Mikir, and it is the absolute land belonging to Rise of Kepanejal as per the sale deed number so and so. That the land in question is under peaceful possession of Rise of Kepanejal since the date of purchase, and we have no right over the land since our father Kantiram Mikir purchased the land on behalf of Rise, and now the Rise is represented by Kepanejal case. We have getting a statement there. And by the Secretary President for the proper maintenance of the land in question for greater benefit of general Rise of the Kepanejal, as such the necessary order may be passed for mutation and correction of the revenue record in favor of Rise of Kepanejal. The next para, that previously we have not seen the sale deed bearing number so and so and wrongly filed the mutation case. They have already admitted this has been filed wrongly by them before a settlement of, and now we have seen the sale deed and the claim over the land by virtue of the right of inheritance is not applicable at all. It is absolutely the land belonging to the Rise of Kepanejal, and we also state that heirs of John Mikir the plaintiff 1 and 2, Sutiram Mikir, as well as Boloram Mikir have no right to claim the land as their own, since the land had been purchased for Rise and it is not their own land, and as such, unless necessary order may be passed for correction of revenue in favor of Rise of Kepanejal, so and so. Here, your lordship, they have pleaded that revenue record should be corrected, your lordship, on the basis of sale deed. That Board of Revenue, it is not interpretation of sale deed. They have not, your lordship, they on the basis of sale deed, they went for, they don't have the original sale deed. They went certified, they don't have the original sale deed. They took a certified copy and they went for mutation because it was muted in name of dead persons, your lordship. That exhibit 5 which they have, that is in name of dead person. So they 2006 they woke up for all of a sudden, and these two persons went out for apply for mutation on the basis of sale deed. Now that sale deed SO has given mutated, then it was challenged by the Kepanejal and all these people, your lordship, before the Board of Revenue. Now, Board of Revenue has to see, so far settlement operation is concerned, everything is a Board of Revenue, your lordship. It's not a declaration of right. Board of Revenue has seen the document and has come to that conclusion, your lordship. They cannot say that it is Board of Revenue has no right to interpret sale deed. Then what is the purpose of Section 6 of CPC, if your lordship see? Revenue Code has got the same jurisdiction as Civil Code, your lordship. Section 6, CPC. They have the power of the CPC for Section 6, if your lordship see. Revenue Code has they have the jurisdiction, separate jurisdiction. Section 6 of CPC, your lordship. Right. Whatever happens.
It relates to pecuniary jurisdiction.
Yes, sir. No, yeah, sorry, I'm sorry. It's 5, sorry. Application of code in revenue codes, sir. I'm sorry, I put the wrong set. Whenever a revenue codes are governed by provision of the code in those matters proceed upon a special enactment applicable to them, silent, the state government may by notifying official get declared any portion of those provisions which are not expressly made applicable by this code shall not be applied to code, and so and so. Then your lordship comes to then if your lordship will see, the revenue code has been given assignment of the settlement of lands. Now, what is happening on the basis of the sale deed? I am claiming the settlement of the land, and because of this own admission of these people, your lordship, the Board of Revenue have passed that order. The background of the Board of Revenue, they went and these people have gone against them, all these people. Then your lordship, what Board of Revenue order, if your lordship will see, it's very clear. Page 239, if your lordship, the Board of Revenue order. Page 239, my lord, as well.
Yes.
Peruse the application dated 29/4/2008 submitted by the appellant. In the petition, it has been stated that the appellant number 1, Boloram Mikir, along with Sutiram Mikir, Kantiram Mikir, John Mikir, as Raj Goria, representing the general people of the village Kapanjal, purchased a plot of land measuring so and so, tag number so and so, under Beltola was from Birendram Pukana, Hirenram Pukana, Birendram by registered sale deed dated so and so. Since the date of purchase, the Rise of Kapanjal are possessing the same, having right title interest upon the land. At present, the aforesaid Dag and Patta have been converted to Patta number so and so, Dag number so and so, settlement. The land is question is not a private land of Boloram or Sutiram, so it is stated, your lordship. Then your lordship says, then I take your, I not take the judgment, your lordship. Then I take your lordship to para 24, your lordship. Because on the basis, because they are, if your lordship will see that plaintiff number 3, defendant number 1, defendant number 2 and 3, they have supported the case of the appellant number 4 in the before the Board of Revenue. And it was on the basis of statement, which could not be contradicted by the plaintiff number 1 and 2. The settlement operation, settlement, the name has been incorporated here. If your lordship see, after hearing the learned argument for the parties and perusal of the records, this is very important. It is seen that in the sale deed numbers, the names of purchase are clearly written as Sutiram Mikir, Kantiram Mikir, Boloram Mikir, and John Mikir. The names of the sellers are written as Hirenram Phukan and Birenram Phukan. Since the Rise Goria is written before the words Barabar Likhitam in the sale deed, it does not mean that the Rise was the pattadar of the land and on behalf of the Rise, Hirenram Phukan and Birenram sold the disputed land. Here, your lordship may have both. It is not their case that Birenram Phukan and Hirenram sold the land on behalf of Rise of this thing, your lordship. That is not the case. They have not stated that. The question here comes when you interpret a document, your lordship. You have seen that way. Logically, you have to see because how this Rise of district has come in, Rise of Kapanjal has come there because it is because these people. It is on behalf of the line because what I have in writing, what happened, they should have been slightly above. Instead of they have taken advantage because it is the same line. They are thinking that this Hirenram Phukan and Birenram Phukan has sold the land on behalf of Raja because of financial. It is not that. They have not stated that the land belongs to us. Because if it is the land belongs to Birenram Phukan and Hirenram Phukan, who has sold the land out of financial, to whom? These people on behalf of this thing. Because since the society was not registered at that point of time, there was no reserve. The people have not, they have come to, as I have shown your lordship, that statement, the property was purchased in the 4 leading persons of the village. They are not brothers and sisters, they are individual, respective people of that area here. So they thought that it cannot, because it's not a registered society. So in their rise of this, society was this, your lordship, the land was purchased. And it was never claimed by them because they said the Rise was in possession of the whole land at any point of time. That's their admission here. So as a result, what is happening here, by virtue of this sale deed, it is clear, he has cleared that because it is the Board of Revenue has the jurisdiction to clarify this position. They have not, they are setting what is the sale deed. They have not. It is not, they are not nullifying the sale deed, they are interpreting the sale deed in the thing. And this interpretation has not been gone into by the trial court also, your lordship. Since it is, I may read again further, but since the Rise is written above the word so and on behalf of Rise, Hirenram Phukan sold the disputed land. As Hirenram Phukan and Birenram were at the time of the pattadars of the land, they were the actual sellers of as Sutiram Mikir, Kantiram, Boloram Mikir, and John Mikir purchased the land, and in the absence of any reason as to why these 4 persons have to buy the land together, it is to be presumed that the word Raj Gariya should have been before the word Barabar in the sale deed. He has clarified the position, your lordship. If the four purchasers would have been stated some business or other commercial activity together, it would have been meant that the four purchasers have some commercial interest in the land, and for the better control of supervision, perhaps the land are purchased jointly. In absence of any such things of record, the fact that a market or a school and one moiles of a house and there is on disputed, it can be safely presumed that disputed land was purchased on behalf of rival. Now here I will pause immediately. What has happened? The land was purchased in 1957. Plaintiff number 1 and 2 had gone for correction of land in 2006. How many years, Your Lordship, see? What had they have been doing for the last so many years? 2006, they went for record correction. Because what is happening, Your Lordship? 2006, they have started the process because they want to take. And I'll show from that they have admitted that possession was never with them, Your Lordship, that I'll come later on. Now, Your Lordship will see, this will show that there was no intention of purchasing the land together. The board of is absolutely correct because they have not placed any evidence or anything. Statement is there to show that they have come together and purchased the land for their own personal needs. They have not stated anywhere, not in the plaint also. There nothing is stated there. Then Your Lordship will see purchase. Then next para 25. Therefore, in view of the points observed above, as both the title and possession are with the rise of tenant, this Your Lordship is very clear. They are not declaring, they are just interpreting the document. They are not conferring title. The title is already there. They are clarifying it. Title and possession are with the rise of Kepanajal, representing the general public people of the village. The disputed land should be recorded in the name of Raj Garya, represented by Kepanajal Ground Committee. It is not necessary to write the words headed by the secretary and the president of the committee as the possibility of creation of a problem in future and any other person except the present secretary and the president of the Unnayan Committee cannot be ruled out. Therefore, as per the direction of the Honorable Guwahati High Court, order so and so, that petition so and so, the matter relating to mutation of the mutation of the suitor is not confirming. Mutation is the issue is mutation, Your Lordship. It's not confirming that mutation on the behalf of this thing. They got it from SO on the basis of same salary and it was challenged because mutation. It is the principal thing which is challenged the mutation of the land. Because the right is title is with us. Mutation of the land has been challenged here, and he has given only mutation of the suit land. It has been examined accordingly, and it ordered that suit land will be mutated in the name of Raj of Kepanajal, represented by Kepanajal Unnayan. The committee registration number will be furnished in the settlement of the so and so. In order to ensure that the ownership of the suit lies with all the public of Kepanajal, it is hereby advised that the land shall be not be transferred by way of sale, lease, or mortgage, and without consent of the village public of Kepanajal. Your Lordship, why this order was passed at that point of time? Because at that point the society was not registered. Because the people were there, since the society was not, it was taken in the name of 4 people, Your Lordship. So as a result, what happened, Your Lordship? The board of rules is absolutely correct. Absolutely correct in holding this thing. Here, Your Lordship, so far in the civil suit, they have not challenged this thing. That the board of revenue has because after this, if Your Lordship will see, in a civil suit, they have not challenged it, Your Lordship, about this observations, Your Lordship. That how the invitation was done in favor of the appellant number 4, Your Lordship. That was not challenged, Your Lordship. The writ petition has said that it will be decided at this thing. Here, if Your Lordship will see the title suit plain, they have not challenged that board of review. They only said board of review given this, but there is no ground of challenge on what basis that this has to be challenged. The mutation was wrong. They have not put any ground there. Now, Your Lordship will come. Then I take Your Lordship to the cross of PW1, which my learned friends avoided referring to it. I just place that thing, Your Lordship. He has admitted that
At page number?
I'm giving you page number, Your Lordship. starts with, it starts with page 61, your lordship will see. He has admitted here, your lordship. He said, what is possible? He doesn't know. He has said that. He said, I do not know about Saniram Mikir, Sattiram Mikir, and Jantiram Mikir. He doesn't know anything about these people, your lordship. Then if your lordship comes to down of 60 to page 62, exhibit original has not been filed. They know exhibit 1 is a sale deed, your lordship. Had there been owner, the sale, original sale deed should have been there. They have filed with the reserve certified copy only. Certified copy. It is the certified copy they have placed it. Because it is their case, they have established on the certified copy only. Then he said, he has admitted, I have filed this suit before the court after 36 years of my birth. Then if your lordship will see, he says, page 63, if your lordship will see, from the date of purchase, my father till 2000, it became 56 years. And after that, I filed this suit in 2013. He has not given any reason why he has waited for so long. Then in the song list, but there was one dark number, so and so dark number. The dark numbers are also different. I'll show it later on. Then if your lordship will see, next page. He admitted it is not a fact. We receive collective money. This is Raj Garia may be the pattadar. He said maybe the pattadar. Raj Garia may be exhibit 2. I have collected in 2006. I have not produced any Jamabandi Chitta or in the prior to. So he has admitted here also. He doesn't have any document. In remarks to column exhibit, it is written Rajwa field in Gaurav. This page is, if your lordship will see, page 201. This document is page 201, I said. Page 201, if your lordship will see, here 201 exhibit call. Here, if your lordship will see, name of the pattadas, these names are there. And if your lordship will see the remark column, this is a document 74, your lordship. This is the document 21/11/74, your lordship. You'll see the date is here on the right hand corner. Then remarks is Rajwa. That's a public land. This is not this thing, your lordship. So now, if your lordship will it is not correct. The Rajwa field is mentioned. He said this. It means the Pattada Garia purchased the land on behalf of. It means yes, admitted. Pattada Garia purchased the land on behalf of rice. He has admitted this fact, your lordship. Then he said, here, if your lordship come down below, in exhibit 5 for the diet except Bolora, rest of the 3 persons has died earlier. That means this exhibit 5 which have, that is in the name of dead person, your lordship. Exhibit 5 assessment is made in the name dead person. So they have relied on exhibit 5.
You were reading from which page?
Page 64, if you like, page 64.
Yes.
Exhibit 5 assessment was made in the name of dead person. That is
yes.
They have said it there, your lordship. I have filed evidence. So then he said, by mentioning the word locally in my evidence of evidence para 12, I understand that locality means people of one particular area. He said. Then he said, next page, 75 families of Kepa in para 12 of evidence. Locality has he said locality has developed the expression Guwahati city incorrect. The aforesaid locality has been changed. So here he has admitted in the people of that area who have developed the land, not he. Yes, clearly 75 families are there. There is a bazaar in a locally developed area. So then, if your lordship will see, the disputed land measuring 9 bighas 2 kotha 1 less. Here I'll take your lordship how the two schedules are different and the land is not demarcated. Also, I'll show those things also, your lordship. Because what he's saying, they are saying Schedule A land is the land which is covered by sale deed, and they are claiming Schedule B land. Then I'll show it from a plaint also, your lordship. That's why I'm making two different lands are there. Schedule A and Schedule B. Schedule A land, they said, is a Schedule A land is covering the land covered by the sale deed, which they are not claiming. They are claiming a Schedule B land. So that I'll come to later because I just pointed out because that concept came here. Here he has said the respect measuring is 9. This is the area of Schedule B land, they said. I have not produced any concern regarding established schools. So no dark number has been given in place of school and Mohila Samiti. No, that is not. schedule a land is at present commercial land, your lordship. They have no relief against the schedule land. I have not submitted consent letter. Then I have not submitted receipt for collection of rupees and from the traders from before the court. So, your lordship, the claim that he is collecting rent from the 2006 onwards and this thing, that is also made by his own statement. Because his cause of action is only from collection of rent, your lordship. They are diffused. That I'll come to later on, your lordship. I have not submitted any rent agreement between the traders. There is no rent agreement. There's nothing as your lordship. So here, then if I have not submitted any document regarding daily market and Lokhra Bazar. Your lordship, I have told you this Lokhra Bazar is a place which is far away from the suit land, my land, covered by sale deed. There are two different. There are differences around 500 meters. They are not same. I'll show by everything. The diagram will come clearly. In my affidavit, I have not submitted regarding.
Both are not adjacent to each other.
No. They are separate land. What it is? They are claiming Lokhra Bazar. Lokhra Bazar is not covered by the suit land. Lokhra Bazar is a separate place.
Lokhra Bazar, that means that the weekly market.
It's a weekly, but that is away from. This is a commercial house.
No, there are two markets. One
Yes.
is a daily market and the other is weekly
Lokhra
market.
Bazar is separate market. They are claiming Lokhra market, Lokhra Bazar. And then if your lordship see in my affidavit, I have not submitted again regarding tenant before the court. So no documents of tenancy, no documents of rent agreement. I have support a collection of rent also rupees 100 from before the court. So here he has clearly admitted that for the purpose of the suit he has filed or the purpose of the cause of action was shown for to save limitation 2011 that I have refused him to take collect rent. But there is no document which he can produce. So he said for 2006 that question arrived. The 2006 he started collecting it. There's no evidence. He has admitted, your lordship. I have shown. So there is no document, nothing, just oral statement. That his cross he has admitted, he has nothing on record. So the whole cause of action started from there. I'll come to cause of action later on, your lordship. Like the collection of traders' rent, so it's a deck 66, the partition of traders, no document submitted. I stated in paragraph 14 of he's denying his own, he's countering his own statements here. Then page 66, I have not submitted any document regarding permanence of as mentioned paragraph so and so. There was no partition of land before one, and even after there was no partition of land. His partition is not there. Then I have filed several cases against rise of Kepanijal. And Kepanijal, within this case, there are the case before town settlement of Vivari so and so. Then he said, then down below, if your lordship will come, I know that defendant 1 to 6 stated in the statement that a land has been purchased on behalf of right and they are now right over there. He has admitted, your lordship, defendant 1 to 6. Here he's saying I am representing a joint thing, but here he has categorically stated defendant was saying that it is purchased on behalf of rights. So it's a clear admission here, your lordship, that defendant number 1 to 6 is also against him, your lordship. Which he claiming even defendant number 3 also who gave the deposition in his favor also is because I showed in the board of review thing he has stated a different stand, your lordship. And I have shown and the right and there. Then your lordship, your lordship down below. I have not submitted any document regarding rupees 70 as the mentioned in the affidavit paragraph. I have not produced and submitted any document that I am entitled 1/4 share. This is very important. How is entitled for 1/4? He has not submitted any document. Because other people are saying it's not that doesn't belong to us, it belongs to rice. All the three, one has not one of the he has not contested anything, but other three. They are saying other two they said they are it's a public land. I've shown from the record also. He has also admitted that I have not before any document where he is paying 1/4 share for this thing. He said 1/4 share I rent and come by this thing. He has which he is claiming he cannot. Regarding area net, I have not submitted any document before the court. Here also, your lordship. That means 2006 that portion also goes away, your lordship. I have not submitted regarding any statement made in paragraph before this court. Then if you in support of Lokhra Bazar, Lokhra Charial, next page 6, I have not submitted any document. So he is telling Lokhra Chariali Bazar, but he is not saying I have no document in the paragraph. I am not a man of that this, your lordship, this is the disputed land is under possession capable and they are running the shop there. Clear admission, the possession was never with them. In fact, the plaintiff also they have not said, they have not stated that plaintiffs are in possession of the, the purchaser are in possession. So there is a difference between plaintiff and purchaser. Purchaser are we. That shows that the disputed land under possession capable. I am not submitted regarding that my claim from 17/2002 as mentioned paragraph. So even that claim also he has not submitted, your lordship. At present, Schedule B land belong to dark number so and so, and 4 kata so and so, and A2 dark number. Here, your lordship, there is no mention of boundary in Exhibit 1 which is submitted in the court. This is very important. Exhibit 1 which is submitted, by which he is claiming, there is no boundary. He has admitted here also. I have not submitted any paper relating to boundary of Schedule B. So Schedule B is no boundary. He has admitted, your lordship. Then he was further cross-examined, your lordship. If your lordship take to next page 68, if your lordship say, your lordship, if your lordship second para down below, I have heard that a defendant has purchased the suit land jointly, not he. And I have also heard that only one person and no capacity person and such 4% person which I have heard from my after 36 years, I filed the suit. Because he has admitted this thing. Then if you watch the next page, I do not know who was in possession of suit land since 1957 to 1977. Yes, 57. They are saying we are in possession. So 55 to 67, that's 7. They are not saying also that after 77 also they are in possession. I came to know from the record in 2006 that a settlement of it was going on from 96. So here he woke up from slumber in 2006. After a span of almost, I think, your lordship, 43. Yeah, I think around more than 50 years, he opened for slumber, your lordship. Then he applied for the settlement for the mutation, your lordship, 2006. In 1995, there was settlement of and the settlement of a previous patta changed to dark number so and so. The settlement was completed so and so days. Then here is, I received the exhibit 3 on 15 September. In exhibit 1, patta Sutiram Kutir was expired so on, but I do not know when the patta expired and patta number who is my father expired so and so. So your lordship, all the names who that 4 names were that they are all dead person. So the question is there can be a patta in name a dead person, your lordship. So that's why I had exhibit 3, exhibit 1 so and so. Then I had verbally informed your lordship, basic. I have verbally informed the field service regarding the death of patta number 1, 2, 3. The first 3, his father and this thing. Only Boloram Mikir was alive here. That's why Boloram Mikir has filed the case before the Board of Revenue. He was one of the purchaser who name on which the land was purchased. He was there in the Board of Revenue after he expired just few days before the suit was filed. Then if you it is not a fact, by considering I have received Kacha Patta, sir. I have not received any Pakka Patta against the aforesaid Kacha Patta. He is admitted here. The aforesaid Patta has been issued in the name of dead person. So your lordship, if your lordship go on below, if the survey officer has issued Kacha Patta in the name of Khepaji and Unna, I do not know. It's important. If after field verification of the disputed land and also after field survey has issued Pakka Patta number so and so there, village capital was in favor of Khepaji, I do not know. Your lordship will see this Patta number is, if you can see that same thing is there, and I'll show later on that the Patta issued to B is of a it is, if you lordship see page 205, your lordship. Page 200, it starts from page 203, exhibit go. This is the Patta issued by issued in favor of the Kepanajal, your lordship. Your lordship will see description dark numbers are there, your lordship. Page number 2 is a dark number, all these things are there. And I will show that these dark, they are not claiming
page number 205.
205, yes. Description of land is there, dark numbers are there. And I will show you to your lordship this. These dark numbers have no relief as claim against these dark numbers from the pleadings, your lordship. That will come later, your lordship. He admitted also here, freedom of the Kachar in favor of, I don't know, he doesn't know about this. He claiming that land also. Then next page, para 70, page 70, your lordship. I have come to know exhibit 795 at that time. I was at 7, so exhibit 9. So down below, if your lordship will see, the aforesaid Bolaram Mikir, he was alive, was on the registered said dated, and the said has purchased the land along with so and so. Down below 70, aforesaid, they said. In the aforesaid case, Bolaram Mikir has given in writing stating that the land was purchased on behalf of Rice. He was the only surviving member. All people, these are all hearsay. He was the only person who was alive at that point of time who was a person who was purchaser of the land on behalf of the Rice of land. The other three has expired. And the said Bolaram Mikir has also mentioned a written objection that Waris of John Mikir, Kanti Mikir, and Sutri Mikir have no right since the land was purchased on behalf of Rice and the settlement was passed an order miscase dated in favor of the applicant, that in favor of them. Then against the order of miscase, the said Bolaram Mikir, he was one of the Kepanese also has filed a case before Assam board so and so. Then it is again. Now, if a lordship takes, I take to next page, page, he was further cross-examined your lordship. They talk of the revenue case also here, he said. In the revenue case, so and so, Bolaram Mikir and Waris of Kantina purchase petition number 2 and Sutira Mikir stated the said land was purchased on behalf of Rice. And they have no right title over that. And accordingly, on 1/12/2008, the revenue board passed an order, revenue case so and so, that a disputed land was purchased on behalf of Rice and according to capacity owners have considered Rice granted if capacity. Now, your lordship may have paused here. Here, your lordship, my learned friend is making a lot of objection that this was registered in the subsequently. That's not an issue. It can be registered any point of time. They are, these people were there. Now, these people are not there. So, as a result, it is admitted that belong to the village, the people of the village also. As they got it registered, then against the registration, they didn't find an objection. How they can be registered? Because in case when you go for a registration of that, they can invite objection. They have no one file objection to that. As a result, they have admitted they have been now it's a registered society. Earlier it was not a registered. Now they have people in the village gathered that and they become more wiser. That since the people have expired, so let us form the society. They have formed the society. So society is consisted of the people of that locality or also. It is not that society is there to avoid that society is formed to take over the land. So if that was so, then people of the village would have objected to it. They are residents of the they are developed, they have stated it's the public who has developed that they are PW in this process stated that. Then revenue paid what is answer accepted that. Then if you look at next page, in the efforts, if you look at the worries of so and so except the worries of Kantiram Mikir, except Benu Mikir have not filed any so and so against the order. Only one of the person has filed. The LR of one of the person has filed that before the writ petition. In the writ petition, where the President of Kepanese has filed objection before the Honorable High Court, since the disputed land is under possession of Kepanese government by virtue of purchase prior to 20 years, that is authority. Yes, it is already stated here. Even before my birth, they were in possession. Now the question, the possession is admitted again in favor of it. Till now, I am in possession of the thing. So when possession is there, you cannot have a declaration without recovery of possession. Either the suit have been suit for declaration, recovery possession, or if they are in possession, suit for declaration and confirmation of possession, which is not the suit. Because we are specifically written, we are in possession, they have not able to, they have admitted the possession is with us. Then you down to page 73, if your lordship go. At the time of filing, Bolaram Mikir was alive. And Bolaram Mikir filed objection aforesaid requested Bolaram Mikir, Jyoti Mikir has purchased display in the year on behalf of this has been stated here. Then if you next page, if you let's see. What is of Kanti Mikir, Bolaram Suti, except plaintiff number 3, have not filed any case claiming right and possession of the Indian Civil Code. It's very important. No one has come. And they have, these people have also not filed possession, claiming possession. Then down below, if your lordship will go down, he said, I do not know that in the year 2000, a Pakka Pata has been issued in the name of Kepanji Pakka. If the Kepanji owner has paid the revenue, I don't know. So it is within his knowledge that Patta has been issued to people. So it has not been challenged, Your Lordship. The question is, the High Court might have said you can say, but the question is, when a patta is issued, it has to be challenged. It has not been challenged, Your Lordship. Patta is not challenged. In the read petition, the patta is not the subject matter of the read petition, Your Lordship. If Your Lordship will see the order, the read petition, I'll just take the read petition order, because they are going to dismiss it, and that's why they have taken that observation, Your Lordship. It is a page 246 High Court order, Your Lordship. I'll just take it. My Lord has got it. It is submitted by Mr. Sharma that as petitioner 1, 2, and 4 had filed a title suit in TS number so and so in the Court of Civil Justice against the present respondent number 2, 3, 4, and so this writ may dispose as infructuous. No review. With the observation, the order of the learned board of dated so and so case number will subject to outcome title suit so and so. Then that order is concerned on. So here, if your Lordship will see, there's nothing on that patta which has been issued here. That's not subject matter of challenge, because that is not the subject matter of challenge in the suit also. Question is, there Board of Revenue order is, but the question is the subsequent to that the patta has been issued, Your Lordship. The subsequent even has not been challenged, Your Lordship. Subsequently, they are saying only after the Board of Revenue I have the patta, this patta has been issued. Definitely after the Board of Revenue order, the patta will be issued, not before that. Board of Revenue patta, because the sale deed was there on the basis of the patta was issued in favor of appellant number 4, and as a result of that, the GMC and other people, they are taking the revenue from us, and the revenue receipts are exhibited here, which cannot be denied by them. Now, Your Lordship will see, based on this, the challenge, the observation that the order of the Board of the subject matter suit does not give them the liberty that subsequent event which has happened after the order of board is not substituted. It has to be challenged separately in the suit itself. Because they have filed the suit in 2013. At that time, the pattas were there. 2009, the pattas was issued after the Board of and all this. So they are in possession. They didn't challenge that. So once they have the issue of the patta in my favor has become had attained finality, Your Lordship. That was not gone into by that trial court, because that was not before him, before the learned judge, Your Lordship. So the question of patta being there, Your Lordship, patta was not challenged. Then if I Lordship take Your Lordship that same affidavit page 74, Your Lordship, he said, page 72 down middle, I do not know that the year 2009, this is very important. A pakka patta has been issued in the name of Khepane General, pakka number, sir. If the Khepane has paid revenue, I do not know. So here, clear admission that this has not been challenged, and he is knowing of the thing. So if Your Lordship will see, next page. Here, that schedule, the area of land in Dainik Bazar is about 1 bigha 3 katha and weekly Bazar 8 bigha so and so. So this is a new pleading which is not there, Your Lordship. Here, weekly Bazar boundary, they have said east is Dainik Bazar, all this thing. Then he has said, I have down below that I have not submitted any paper relating to aforesaid boundary. So he made the boundary by himself. I had stated the boundary from my knowledge because this some mistake is there. Your Lordship may turn to the SMS version, page 110. It is SMS version, just a typing mistake is there. 110, the SMS version is there. Your Lordship see, page 110, same thing.
Okay. Okay.
Page 110.
110.
Yes, sir. Ukto Sarihima.
Yes.
Ukto Sarihima সম্পর্কে মই আদালতত কোনো কাগজ দাখিল কৰা নাই। মই নিজে জানি চাৰিসীমা কৈছো। Your Lordship, he's on his own, he has defined the boundary. বিবাদীয়ে জমিৰ বিষয়ে মই দেউতাৰ মুখেৰে গম পাইছিলো। দেউতাই মোক 11 বছৰ আগত জনাইছিল। He doesn't know anything about all the boundary also, he doesn't know. It's admitted. So if the schedule is not, how can they determine the, in case of immovable property? He has admitted, this clear admission on this part, Your Lordship. Right? For your convenience, Your Lordship, I made a family tree that will be helpful for you to know the family tree, otherwise it get confused. This will be helpful here because others defend all this thing. I've made a chart that way. Your Lordship will see, I'm going to basic things here, Your Lordship. If Your Lordship will see. I'm coming to the plaintiff here. Just plaintiff, Your Lordship, to page 35. Your Lordship. What is the suit for, Your Lordship will see?
Page number?
35, the plaintiff, the plaintiff. Page 35, Your Lordship. Suit for declaration of right, title, and interest of the plaintiffs, not defendant 1 to 6 years. Here they want the right title of them over the suit land, describe its schedule bay, and also a declaration of the right along with defendant to collect rent from the traders and offer the organized so and so extent of share really. So here, Your Lordship, I am for here. What your plaintiffs are asking for a relief of declaration title, not the defendant number 1 to 6.
That is their submission.
It is what it is there, my friend. It is from your record. It says heading. I'm not saying that. It is suit for declaration of right, title, interest of the plaintiff over the suit land. Describe each other. So where the defendants are not there. So declaration title they want for the plaintiffs only.
They have to submit.
Please don't give running comment. This is specific. I'm talking for a record. It is there. And declaration of right along with defense to collect rent. That I've shown you. They have said that they don't know anything about rent thing also. And traders collect from Lokra was the organized suit land extent of share so and so relation. Here, Your Lordship, PW1 is cross asset. There is no document by which I can claim 1/4 share. He has stated there, Your Lordship. Now, if Your Lordship will see in the plain itself, para 2, which my learned friends rely, I just read to para 2, page 36. That after purchasing the said land, measuring 9B of 4 crore lesser, the name of said Sutiram Miki, Kantiram, John Miki, and as aforesaid were mutated and corrected in the relevant record so and so under Moses one in the district without any objection. It is pertinent to mention. It is pertinent to mention that KP Pattanaba so and so district of it is pertinent to mention here the settlement of the 95 original Patta 102 purchased to 159 and 125 respectively during the last settlement of aforesaid Pattanaba Pattana once a new dark number so and so. So, Your Lordship, I may pose here, Your Lordship. This he has claimed this Pattanaba. I show what the document says. My document. Here, if Your Lordship will see, this is Patta number 771, new dark number 30, so and so new respectively. Now I take Your Lordship to the Patta issues to me, Your Lordship. Page 205, Your Lordship will see. Page 205. The Patta issued in my name is here. If Your Lordship say Patta number is 1442. Here they said last week they came to 771 new and that number so and so. So 3030, how is it 3070? 3031 is 3071 and 3072, Your Lordship. So this the land is totally different, Your Lordship. They are claiming this land, Your Lordship, in their plaint. And down below also the same, these are all different, your lordship. Dark numbers are all different, your lordship. Next para also, same thing. Then if your lordship will see, your lordship, I may point out one thing which I was telling your lordship. If your lordship see page 35 bottom, that I just tell you. Page 31, but that sale deed which is scheduled to be a land. That's what I'm telling. They are seeking claim. If your lordship see, dark number so 35 down below, your lordship will see that this land over there, the said land is fully described in Schedule A below. Here it referred to as Schedule A land. Schedule A land is the land which according to is the covered by sale deed. And they are claiming Schedule B land, your lordship. That's why. Then if your lordship will, I'll take your lordship to this. Now, if your lordship will see page 48, they have given the schedule, your lordship. Then I come to the prayers also. Then. Schedule A land, if your lordship will see page 48, a plot of land measure 9B or 4 kata is covered by dark number so and so. 33 same your lordship, not 3070. KP button so and so newly that east is stream, west go down, drain, road. Your lordship, then schedule B land is important. A plot of land measuring 9B, it should be 2 kata, wrongly it should be 2 kata, your lordship. So one lesser covered by dark number so and so 30 KP button and bounded by east stream school. Now, your lordship, the boundary is passing stream. Now I'll show here itself. At page 40 of the plane, they have para 13. They have this is important. Para 13, I'll show what they have said. There is the eastern side, there is a stream, your lordship. At the para 13, they have stated, your lordship. Here, your lordship is saying the eastern side, they say, just keep it. Para 13. There are few shops or regular market eastern side of Schedule B land. Your lordship, eastern side of Schedule B is a stream. That means eastern side is outside the Schedule B land. Here, your lordship, there are few shops or regular market on the eastern side of Schedule B land. The regular market is there over the Schedule B land. So, over the eastern part of the Schedule land, eastern part is a stream. So it has to be beyond the stream. That means it's beyond the Schedule land, your lordship. So your lordship will see now the relief they have claimed on this. As I told your lordship, page 46, prayer A. For declaration that a plaintiff has got joint right, title, interest along with defendant number 1 to the Schedule B land. No Schedule A land is not there, your lordship. Schedule A, they want a Schedule B land demarcated somewhere else. And they have categorically stated that he doesn't know about the boundary, he has just on his own, he has made the boundary. So the question is, the land is undefined, your lordship. Schedule is not clear. That I've already told your lordship. Then now I come to the your lordship, the cause of action. Which by learned friend, cause of action, if your lordship will see. The cause of action they have that's para 27, if your lordship say, page 45. That the cause of action for finding the suit arose in 1/7/2011 when the defendant restrained the plaintiff from collecting rent from the traders and the market organized CLP land to the extent of share on the subsequent thereafter when the defendant refused to share the thing. So your lordship, PW1 in his cross, he has stated, I showed to your lordship, he doesn't know anything about this thing. I've shown your lordship. Yes, yes. Cross reference I give your lordship. So your lordship will see, I have shown that cause of action cannot arose here because he has already stated that he has not produced any rent. I have shown that. Now the trial court order also, if your lordship see, they have rejected that plea on the question of claiming area on the basis of cause of action, your lordship. Trial court. If your lordship will state your lordship comes here, your lordship. I just page 23 of the European judge. I just take that, your lordship. Now during, my lord has got it, page 23. Now during cross-examination, PW1 stated that with the consent of the people of the school in Mailasa was established over the land and the school was so and so collected rent, but no receipt having submitted. He also stated that the land was not partitioned between them. It is also stated in the case that purchased the year and you are not able. Your lordship, here I may pose one more. If the land is jointly owned by 4 persons, your lordship, the relief would have been for partitioning of the suit land, your lordship. That they have not gone. Because other people are saying it is not our land. So the question is, they should have partitioned the suit and this thing. They have no suit for partition was filed in respect of the land. And there is nothing in the document, sale deed, that everyone is entitled to 1/4 share. Nothing is stated there. Sale deed also doesn't say that give them the 1/4 share also, your lordship. Then if you look at that page, I just take your lordship. It is also said because since the land was purchased in that page 20, hence he is not aware of who was in possession 1955 to this. The evidence of the plaintiff witness are clearly cogent. Defendants failed to deliver testimony. You know, then I take your lordship to the next page. Your lordship will sit down to it that the cause of action in respect of the collection of rent, no documents were placed on record. The plaintiff showed the amount of rent that is collected on daily or weekly functioning the suit land. Moreover, no witness is to show extent of entitlement share in respect of suit land collected from the market. Hence, there is no evidence on record to show there is a monthly income sum from the market. Regarding entitlement of collection rent between plaintiff and defendant, it is a matter of internal agreement. There is no internal shown here. And hence liberty is given to make an apportion of share equally among the parties, which of course decides on such. No, and even no decision has to be given in this court with respect to entitlement share the rent collected. So your lordship, they have trial court rejected that. So now question is, if that the claim for rent from that 2006 and that 2011 has been rejected by the court here, the trial court. Then if that is non-existent, then the cause of action also goes away, your lordship. They cannot say they could not establish the fact that 2000 they prior to 2001 they were collecting rent. After that they stopped collecting. They were prevented from collecting rent. They have admitted there's no rent agreement, nothing, no rent received prior to 2011 was showed by them. No rent agreement, nothing. They've admitted PW in his cross-examination. So your lordship, this this is a question of absence of cause of action, because this was planted just to avoid the limitation, because 57 declaration of title suit, you cannot have it because bar of limitation is there. So if once you, the article 58, that bar of limitation 3 years is there, then you even when they came to know about 74 also, that they didn't do 2000, they have not filed a suit in the period of, so law of limitation, they cannot get over the period of limitation, Your Lordship. And question is, Your Lordship, when admittedly the possession is not there, I showed the Ramda that case, Your Lordship, that with suit, you cannot file a suit for declaration of title without possession. And if Your Lordship will see the relief, you are giving the rate, claim what the defendant was until, and the ground E, you are injunction the defendant to reclaim also, Your Lordship. That prayer, I've already shown what I again show you to Your Lordship. That prayer, if Your Lordship will see, 47. Please for E, my lord has got please 47.
Yes.
Permanent injunction restraining the defendants, their man and agent, from disturbing the plaintiff, not defendant 1 to 6 is gone, in collecting rent from the traders of Lokara Sahara weekly or daily market and held over scheduled B land to the extent of share of plaintiff number 1 and 2 at 175 and respect plaintiff was 150 and 50. So, Your Lordship, she's claiming injunction that they are only entitled to correct an injunction against the other. So, how could the prayer A and prayer E are totally contradictory? Prayer A, you are saying our the portion of this thing, Your Lordship. This prayer, sorry, prayer B also, Your Lordship. They 1/4. How can there be 1/4? Whole, if you see the Your Lordship, prayers are all contradictory here. One is eating another. So you cannot get an injunction. You are claiming that we are joint ownership, and you are having an injunction against me. What the plaintiff 1 and 2 are having injunction against plaintiff 3 also. Only 1 and 2 has been written here, Your Lordship. Now 3 is not missing. Although they are same plaintiff, because 3 has not supported the case. Though 3, 1, 2, because my learned friends read that WS of the defendant 1 and 2. Defendant of 1 and 2 has only filed the WS. They didn't come for evidence at all. So as a result, their WS cannot be taken as a gospel truth unless they are subject to cross-examination. So they cannot rely on the statement when the WS here. But the affidavit filed by them in the Board of Revenue is taking a contrary stand, which is supporting the appellant number 4 here, the appellants here. So here we have to go by that statement, and Board of Revenue is absolutely correct in determining the because there is clear admission on their part. She did not go to the documents. The admissions are there in the own affidavit by these people. And as a result, they have stated the rice is the owner, and they have stated that way. And it was given that way. So, so Your Lordship will see the prayers are contradictory. If for a convict, for a declared right, got joint title, declare that plaintiff has got joint right, title, interest, and along with defendant 1 to 6. Joint title. But if they pay defendant 1 to 6 has the joint title, how they are not prevented from collecting the rent? But that's classy. And order 1 rule 8 doesn't, they are giving a representative capacity. They had no file application order 1 rule 8. They should have transferred them at plaintiff if they were so much interested in giving relief. Since these people did not support the case, they made it defendant. And defendant 4 to 6, who is the son of Boloram Vikir, has contested the matter. He said it's not throughout their contested the matter, it's not the land of us. And even a Board of Revenue 1, 2, 3 is also there. 1 to plaintiff number 3, the Board of Revenue plaintiff number 3, defendant 1, 2, 3. They all support the case. Land belongs to rice and possession of everything is there. If you actually see the affidavit, it's categorical admission there. So there's nothing rest on all those things, Your Lordship. So there is no question of any. So Your Lordship will see here that they are not able to establish anything on the cause of limitation is there. they're sidetracking the whole issue and going in a different issue of joint thing declaration of the, Your Lordship. Because my learned friend was stating all these things, Your Honor, just. If Your Lordship see, my learned friends relied on para 24 the plaint. Para 24 the plaint, page 44. And now just got it. That the plaintiffs are not getting single parting from the collection of rent from Schedule B land with the effect of 171. Earlier this, till 170, the plaintiff requested the defendant give the share and allow them to collect rent from the market to the extent of the share as they used to collect, but the defendant forcibly illegally by collecting the rent from with market rent. You know, this statement made it a plain has not been supported by PWD's cross. My learned friend was saying that I have not denied. It is they have not. It is the burden is on them to establish it. Where it is not a case of mere denial or something. Cause of action is that I thought that in the WS I have to make a pleading. Pleadings has to be there. How the cause of action is not there, it is bad for me to establish. When they take the cause of action, it is the burden is on them to prove the cause of action exists. They fail to do that in their cross. They have. I showed that cause of. He is saying that I don't have anything. Then this is nothing. The cause of action fails here on 172. So this, if this date goes away, it's not by limitation, Your Honor. Even the trial court has not accepted this findings. Also, trial court has said they couldn't establish that no documents are there that they have been deprived. And that's why the area 21 lakhs claim that has been rejected by the court. They claim on that we calculate 21 lakhs and ought to be recovered as area rent from that period from 2006. The court has rejected because they are not able to establish by any document that they have tenant of these people. So this cause of action para 20, which my learned friends hammering on, cannot stand on his own. Your Lordship, Ramdas case which I have given you, the plaintiff has to establish case on his own pleadings, only evidence, not on the shortcomings of a defendant, witness or anything else. So there is the evidence of PW1, PW3, their evidence which they are not able to establish the facts at all. With PW3, Sovereign Mitra, which they are relying, they have not established the case also. He is saying deny, but PW3 will be, sorry, DW who Sovereign Mitra, the defendant or three, I very different, that will be better. The defendant or three witnesses will be contracted by his affidavit there. He has made an affidavit there before a board of revenue, which I have read to Your Lordship, that it is all right. Collection was made of the public, which my Lordship, there is no evidence of collection of by, but it is their people have admitted the fact that collection was made from the public to purchase the land. That I've shown Your Lordship. Now Your Lordship will say it is pertinent to mention next para page 40. Pertinent to purchases of land had countries possess land jointly. With the purchase of land. Not the plaintiff. They have not said the plaintiffs are in possession, that they have not stated anything. Then they said after date of 3 purchase, legal country to possess scheduled and land jointly, and the land has not been divided among the co-share by mates and the plaintiff was still in opposition. The plaintiff number has got one shop in the market and she herself used to run the shop, but due to personal limit, she has given her one. Your Lordship, plaintiff number 3 has given an affidavit before the trial. This doesn't belong to us. That I showed that board of revenue affidavit. Plaintiff, this is plaintiff number here. It is his statement. It is not a state. They have not examined PW3, plaintiff number 3 as a witness. They have not examined plaintiff number 2 to establish this fact. PW, how many with the PW1, PW2? Two witnesses are examination. At PW1, PW21, that one land agent, he doesn't know every person. He just from the this thing. At PW, the DW, that defendant number 3 was another witness here. So none of the said this thing has not been established here. So the question of personal, this is a statement. Even PW1 in his statement of say he didn't state this thing that she is in possession and she was running a shop. And the cross also he said possession was always with them. So this is contradicted, Your Lordship. Then para 6 he said the right title interest over the plaintiff over the scheduled bill land have been clouded on account of judgment of revenue board and also on account of deprivation collected in the market value. So Your Lordship, the deprivation has been rejected, Your Lordship. They have challenged the revenue board order here, Your Lordship. I said there's no prayer on this thing that there should be a declaration that the revenue board which are given a right that should be passed also. That prayer is not there. Without making a prayer to the effect that the order of what passed by the revenue board is cannot confer a title or something like that. That's not there. And as I told you, Lordship, they have not challenged us. And pattas or lands are also different. My learned friend has stated that I have not filed a counter suit for declaration that the sale deed is bad. Why should I file, Your Lordship? Because the document is not in my against me. It has only the thing rises because they are not able to explain how this name has come. Neither have played, not the cross also, they haven't stated anything. How their document, how by which they are the owner. They specifically they could not rebut it, but rather they have admitted it. PW1 with the plaintiff number has admitted the fact that it is in possession, and he has stated that from 1957 to 1953 to so 87 or something. He is not aware who is in possession. So, Your Lordship, possession, everything is admitted, Your Lordship. How can a decree be passed on such admission against the plaintiff? They have admitted the fact that we are in possession, even ownership also they are in favor of right, and their witness also examined that, Your Lordship. Then my learned friend has gone on the interpretation of clause of sale deed. He is saying that Board of Revenue cannot interpret the clause of sale deed. Then, in that case, how did the settlement officer give them the mutation in their favor? In favor of plaintiff now one, if the Board of Revenue settlement officer will also be depart from seeing the sale deed and giving a this thing, because it is the order of settlement officer which is under challenge. Where settlement officer has used the sale deed to confer to give mutation in favor of plaintiff number 1 and 2. And it is there the appellant who are defendant number 4, appellant number 4 who filed the appeal, and the father of defendant number 4 to 6. They filed an appeal stating that this land belongs to the public, and he, at that time he was the only surviving person who could vouch what's correct. Sale deed, he was a party to the sale deed also. So he can now in that case, the sale deed is there. The court is only seeing what is the position, who is the owner of. Logically, if you see the sale deed has been executed by Hirenram Phukan and Virenram Phukan. They are the owners of land. There is no statement in the plain or anywhere that the Raj of Garia, the appellant number 4, at who is the Raj of Garia is Sorry. See, Your Lordship, we have, the appeal was filed on the basis of sale deed. Now, if the Board of Revenue cannot go, it's a judicial body. It is not setting aside the sale deed. There is no judgment to the effect that the Board of Revenue cannot interpret the sale deed. If the interpretation is wrong, we should challenge the trial court. Did you challenge it? No. They have not challenged that interpretation paid by this thing and interpretation paid by the Board of Revenue in respect of the sale deed. They are not competent. There's nothing in the plain. They have not stated in the plain that the Board of Revenue is not competent to interpret the interpret. He said he has not declared sale. What my learned friend says, declaration he cannot give. He cannot declare the sale deed to be bad. That is a separate issue. But he can declare this sale deed is pertaining to these people. These are two different aspects. Sale deed giving a what my learned friend is correct. If the sale deed has been cancelled by the Board of Revenue, then the question of civil court comes. But here, sale deed has not been cancelled. Sale deed has been interpreted. Sale deed has been interpreted to show that this is the land belongs to the appellant and this 4% purchased on behalf of this. So there is no question of this all the judgments coming into because these are no this judgment doesn't appear in it. And so far, by learned friends relied on 2009 4 SCC. That judgment is totally on a different point. That is not on the issue here. That is a 2000, if you issue 2009 4 SCC, that yes, my learned friends given the compilation. It is a case of registration of document here. 2009 4 SCC 193. My learned friends given that compilation.
Yes.
Your Lordship will see, let me go to the head note, Your Lordship. It is on section 47 for registration of sale deed without payment of partial payment of sale consent. Effect of transfer determination of intention of that. This is a real thing, Your Lordship. Here, what has happened? The sale deed was registered. The payment was not made, part payment. So whether the sale deed is valid or not, that was the issue. So Lordship will see, I just read the portion, Your Lordship. Just held those on such a title will normally pass to the purchaser. From the date of execution sale deed, true test is the intention of the party. Registration is primarily proof of an intention to transfer property, but not a proof of operating transfer. If payment of consideration is a condition present for passing of title, held title would become title would not pass until the full consideration is paid to a seller. Such intention is primarily to be gathered from recitals of the this is something else. Where recitals are insufficient or unambiguous, the conduct of the parties can be looked into subject to provision section 90 Evidence Act 90. Your Lordship, here I may pose, Your Lordship. Here it is absolutely clear. The parties have themselves said it belongs to Rise of Garia. Plaintiff number 3, defendant number 1, defendant 2 and 3. 4%. They are also a legal heirs of some person who was the purchase, who was the party to the purchase. Then if you are in the instant case, since the parties had intended title of property to transfer only on payment of full consent, an appellant purchase failed to make full payment, held responsible were justified in refusing to make endorsement of sale deed as token of admitting it. Title therefore did not pass either on execution or sale deed. So Your Lordship, this is totally a different matter. Recital is a para 19, which my learned friend said, it's on a different issue, Your Lordship. If Your Lordship, if I read from here, Your Lordship, para 15, the judgment. Para, my Lord has got it. The question posed for consideration is whether, my Lord has got para 15. The question posed for a consideration is whether title to the disputed product passed to the appellant when the sale deed dated 2683 was registered on 26/10/1980, though admitted no amount was paid towards consideration of the respondents. Sale is defined as being transfer of ownership for a price. In a sale, there is an absolute transfer of all rights in the property sold. No rights are left to the in transfer. The price is fixed by a contract adjacent to the conveyance. Price is the essence of the contract of sale. There is only one mode of transfer or sale regarding immovable property of the value of rupees on a mode, that is by registered document. It is now well settled that payment of entire price is not a condition precedent for completion of sale, passing of title, section 54 of the Transfer of Property Act. Transfer of ownership in exchange of for a price paid to or promise or part paid and part promise. If the intention of the parties was that title should pass on execution and registration, title would pass to the purchaser even if the sale price or part thereof is not paid. In the event of non-payment of price or balance price, that the case may be, there the remedy of the vendor is only to sue for balance price. He cannot avoid the sale. He, however, intends to charge upon the property for the unpaid part of the sale price prior to when the ownership of the property has been passed to the buyer before payment enters under section 54 of the Act. Normally, ownership and title to the property will pass to the purchaser on registration of sale deed with the effect from the date of execution of the sale deed. But this is not an invariable rule as the true trace of passing of the price in the intention of the buyer. Though registration is prima facie proof of an intention to transfer the property, it is not a proof of operative transfer if the consideration price is condition precedent for the passing of it. Now, para 19. The answer to this question, whether a party's intent to transfer owners should be merely by execution registered or of the deed, or whether intent to transfer the property to take place only after the receipt or entire, would depend upon the intention of the such intentions primarily to be gathered and determined from the recital of sale deed. When the recital are sufficient and insufficient in surroundings, the conduct of the parties can be invoked into a certain intent of limited so and so party. So your lordship, there is no assistance to my learned friend, your lordship. Now, because since my learned friend retired of sale deed, I have to take a lordship of sale deed also. That will make the thing absolutely clear. Sale deed is as your lordship is at. Page 186, your lordship. Page 186, your lordship. I check your lordship. Because here recitals are also very clear, your lordship. Purchaser is says, so this 4% your lordship. All right. And seller on behalf of right
You are
of
referring to
yes,
page
I just
number 186.
186 here.
Yes.
That's sale deed, your lordship.
No.
If your lordship will see, sale, and next page 187, if your lordship will see, they have a signed by 2 persons. Virendra Bukan and Virendra. It's not on behalf of Raj of Goria.
Yes.
Page 1, it's signed by 2 persons of it. It is not stated it's on behalf of Raj of Raj Goria. Your lordship. So here it has to come above. And surroundings are there. This judgment is helping me that the surrounding circle are the affidavit filed by these parties. Defendant number plaintiff, defendant plaintiff number 3, defendant number 1, 2, and 3, and even PW1 in cross. He is saying that we are in possession of the property since beginning. They are not in possession. Possession is there. We are collecting and everything has admitted. The issue is this surrounding will determine the sale deed in favor of the applicant number 4. So this nullifies the argument of my learned friend that the Rajgaria and this thing is this only thing the writing, while in writing that the writer, deed writer has written like that. The intention has to gather from the whole thing. These things plus the evidence, plus the affidavit of the parties. The parties, even the plaintiff number 3, this all this thing is up. I thought they say I am not given independent. It's not my question of giving independent evidence. They are admitting it. I am there. And question is, they are not saying they are in possession. They are saying I am till 1937 and 1957 till today. I am in possession. So how can the disposal be anything? And this if the court gives a declaration of title in the paper, it cannot give anything. And how can an injunction be given to property which is not in their possession also? Then my learned friend has relied on Order 41, Rule 31. order 41, rule 31, your lordship. Oh. Because my learned friend raised an objection also that I filed an appeal giving all documents haphazardly to create. He got confused of the thing. But if your lordship will see order 41 rule, it is only saying that it should be memorable and impugned judgment. They have not, the rules have not prescribed and what way I should place the documents. The documents are placed for the convenience of parties as well as the court. Because it is there in the record, it has been placed so that this honorable court does not have to go to record every time. So it is at a proper place, and they have not denied the documents also. That these are not those documents. So that your lordship will see order contents. If you order 41, rule 2. Contents of memorandum. The memorandum shall set forth concisely and under distinct head the grounds of the decree appeal from without any narrative such grounds are numbered considered. When an appeal against a decree for payment of money, so and so, your lordship. So grounds to be taken every appeal. So here, your lordship, there is no prescribed procedure that how should file the documents are filed, records are filed just for the convenience of the court, so the things are there. Now, my learned friend has relied on order. If your lordship see order 41, rule 24, your lordship. I am relying on this, your lord. Where my lord has order, where evidence on record is sufficient, the appellate court may take care. Where the evidence on record is sufficient to enable the appellate court to pronounce a judgment, the appellate court may, after resettling the issues, if necessary, finally determine the suit, notwithstanding that the judgment and court from which decree and appeal is preferred has proceeded wholly upon some ground other than the appellate court proceed. You know, this gives absolute abundant power to the appellate court to decide the issues, which my learned friend said that can be done this thing, statement of this thing. Then 31, which my learned friends relying on, contains date of signature of the judgment. The judgment in the appellate court, point for decision thereon, the appellate court in writing shall state the point. The judgment of the appellate court shall be in writing and shall state the points of determined decision there so and so, and shall the time pronounced. So this is a question of how the judgment is. It's not my case. Order 41 rule for this thing. How the judgment should be, that's the paragraph of the code, your lordship. So then, question of consequential relief. Here the person question of consequential relief doesn't arise. My learned friend says as if they have got a relief, now on the consequential. It's not a question of consequential relief. It's a question of whether you got a primary relief. Where you are not entitled for primary relief. If you are not entitled for primary, there is no question of consequential relief. Primary relief, they are not able to establish how the period from 1957 to 2013, how they have covered this period. The non-receipt of rent doesn't give a declaration of title. Even they didn't have title at the earlier also, your lordship. That 2000 they have admitted that 74. I showed the chit of 74 also. That document that is annexure just 70. That's page 201. Yes. Page 201, your lordship. Exhibit. It is a document 21/11/1974, your lordship. Here it has been Rajwa, your lordship. This document was already there in record. So your lordship will see here. So question of when you are not entitled to primary relief, how can you get a consequential relief? Because there are judgment to the I given the judgment, I need not refer to it. I said that if because order to rule 2 is also there. Order to rule 2, your lordship knows that I do not cover because you have to claim all the relief together. You cannot have a piecemeal thing. Here, your lordship, they should have gone for declaration of title, recovery of possession. Because they cannot go, because if this two they are barred by, hopefully they barred by limitation. 57 Yeah, the sale deed cannot be interpreted now. They cannot claim a title over it. There's nothing. This I have heard from my father, I have heard from my mother, all these things. That story doesn't count. Because their evidence says, I was not born. You are not born, that's fine. But when you question that doesn't say your limitation. Your parents didn't exercise that right. You are not born, no doubt, but your father didn't exercise that option. So you cannot say, I was not born, I was born later on 77 and 77. I came to know from mother the story. And you cannot jump from 57 to 77 like that. Then you say, go saying that all this thing. I heard from my parents, I was a child, 11 years, all of these things are of no consequences. Because you have to, under law of limitation is very harsh here, Lordship. Because it gives a right to the other person. Question here, Lordship, if that is so, that adverse position also comes in. I have not claimed adverse position, but question of he is, because what have we done with the people have been in position for such a long time? You have admitted I was in position from the, till now you are saying, you are not saying that you are in position. You said, plaintiff doesn't say that. And plaintiff number 3, whom you said he had a soft for sometime 2010. What about before 2010? So all this thing, she has not stated in her affidavit before the Board of Revenue also that she was running a shop there. Nothing was stated. So all these things are story made out there. That cannot save the limitation. Cause of action is not a limitation is barred. Suit is not maintainable because declaratory suit, your position that cannot be done. Just order to improve all this thing. The issue is, Your Lordship, then judgment I've given already. That is AR 1970 SC 2635 I've given. That specific review. If you are not in position, you cannot claim title. High Court judgment I have given that I need to trouble Your Lordship on that. Then then the question of joint decree. My learned friend has taken a plea of joint decree. How can there be a joint decree when the person are divergent? Because if your Lordship see the pleadings, he is claiming right title only for himself, plaintiffs. I showed that portion. He is claiming for the plaintiffs only, without claiming a partitioning of the suit land also. So there cannot be joint decree. There will be joint decree. By virtue of joint decree, he cannot bypass this order or this order. My learned friend not dealt with this provision order. I just stated those things that who should be order one. My learned friend not dealt with those issues, Your Lordship. Order 1, Rule 1, Your Lordship. Who may be joined as plaintiffs? This I have read it. All person may be joined in one suit as plaintiff where any, my lord is certified. Order 1, Rule 1, Your Lordship.
Yes.
Who may be joined as plaintiffs? All persons may be joined in one suit as plaintiff where any right to relief in respect of arising out of same act or transaction or series of act or transaction or alleged to exist in such person where jointly, separately, or in alternative. And B, if such person brought separate suit any common question of a fact. So this is one. Then order 1, Rule 3. Who may be joined as defendant? All person may be joined in one suit as defendant where any right to relief in respect of or arising out of the same act or transaction or series of act transactions alleged to exist against such person, whether jointly, separately, or in alternative. B, if separate suits are brought against such person, any common question of other. Then order 1, Rule 4, Your Lordship. Court may give judgment for and against one of them. Judgment may be given without any amendment for such one or more of the plaintiffs. My lord has got it. As may be found to be entitled to relief for such relief as he or they may be entitled to, against such one or more defendants, this is important, as may be found to be liable to according to respective liability. Your Lordship, then Your Lordship, order on rule 8. This also they are down, whether there are numerous persons having the same interest in one suit. One person or such person may, with the permission of the court, sue or be sued, or may defend such suit on behalf of or for the benefit of all persons. Here this is not done. The court may direct that one or more such person may sue or on behalf of suit or to defend such suit on behalf and benefit to all persons. Then the court shall, in every case, with permission, direction given and sub rule of the plaintiff, give notice institution of suit to all persons either by person. So, Your Lordship, this clause has been not complied. They cannot represent defendant because it's not order 1 rule 8. They have not been authorized by them. Then, Your Lordship, I come to order 2 rule 2. Your Lordship, suit to include the whole claim. Every suit should include the whole of the claim which a plaintiff is entitled to make in respect of cause of action. But a plaintiff may relinquish any portion of the claim or bring the suit at jurisdiction. So, Your Lordship, it's very clear. Here, the suit should have been for declaration, possession, and all those things, Your Lordship, which has not been done, Your Lordship. Then, that omission to sue for one or several relief. A person entitled to more than one relief, subclause 3, Your Lordship. Respect the same cause of may sue for all or any of such relief if he omits except the leave out a sue for all such even. So this has not been done. Now, Your Lordship, there is then my learned friend was making a submission that okay, amendment right here. Yes.
Mr. Sodre, we have some other matters also.
Yes, I'll finish it. Your Lordship, it will take some time, Your Lordship. Can make it part of fixed on 1st of October if you want.
1st of October. Yes, Mr. Goswami.
Lordship, that is why I am submitting on earlier occasion, it should be in October. They are arguing whole cases again. I will take only 10 minutes. If his reply is written, I will 10 minutes. I will finish the matter.
Let it be 1st of
Lordship
October.
will finish the matter. Because it will, Lordship, I do not want. They are getting the benefit and that is why they want to
What?
get the benefit.
Let it be 1st of October. I will finish it. 1st of October.
1st of October.
Yes, sir. As part of
Or Mr. Sodre, learned counsel for the appellant, and Mr. Goswami, learned counsel for the response. Place the matter on 1st of October as part heard.
Your Honor, if it's not part heard, it will go down. If it is not written part, it goes down.
Our part heard hasn't reached today, Manoj.
Deeply highly obliged.
Item 12.
Item 12, part heard matter.
Yeah. I think my learned friend on the other side was asking for tomorrow or Monday if it is convenient to Your Lordship.
I'm ready now.
Are you ready now?
It has taken a lot of time.
Yes, can we fix it tomorrow?
Yes, tomorrow. Tomorrow.
Tomorrow. Yes, Mr. Hazarika,
Tomorrow is fine.
at 2 o'clock then?
I'm grateful.
If I am in the some other court, Your Lordship will kindly adjust me. Tomorrow I want to do this case. It is somehow only 5-10 minutes.
No, I have no problem, but Mr. Hazarika may have some
I
problem.
do this matter.
So 2 o'clock tomorrow.
Then adjust it, then I have no problem.
There is no problem. We will
Okay, okay.
Tomorrow.
Okay,
Tomorrow at 2 o'clock.
at 2 o'clock.
I'm grateful.
Mr. Hazarika at 2 o'clock.
Grateful, Manoj.
Okay, okay.
There is an interim order.
Interim order continue till tomorrow.
Deeply obliged.
Manoj, on the last occasion, the interim order was not extended, Manoj. They didn't
No,
ask.
extended it was, perhaps extended.
No, it wasn't.
Okay, okay. If not extended today, we will extend it.
Yes.
Okay, okay.
Yes.
So other matters, may take a date from him.
Lordship 30 and 31, Lordship.
Take a date from him as per your convenience.
Lordship,
13 and 15, kindly please.
my lord, I seek your indulgence, my lord. So far as the item number 18 is concerned, my lord. Mr. Dor is outside from Delhi, my lord, to appear before your lordship. So on next Tuesday, my lord. I have taken from the other side.
No, before vacation, it would be difficult, right?
I have taken from consent from JI Barui also. my lord.
Before vacation, it will be difficult.
Earlier occasion due to the paucity of the time, my lord, of this one, record letter has been hard. So that's why.
So take it that from him.
My lord, obliged.